हेलो, हेलो।
say something?
I'm only waiting my turn.
In the other case,
So that we will take up after this. I think we hope to conclude. I'm told virtually we are, unless Gupta takes a long time. I think we are virtually completed. Maybe Mr. Chidambaram may have to reply if he chooses.
There were one or two others who wanted to address your lordship.
That we will give them time, no
I
problem.
request you, after the respondents conclude,
Ah.
the lordships may hear those two or three advocates for 10 minutes, and then I will rejoin you.
All right.
My rejoinder won't take too long.
All right.
My lord, to get back, my lord, on track, my lord, may I request your lordship, my lord, to keep in front of you the heads of submission which I gave your lordship yesterday,
Yes.
so that, my lord, I can quickly follow that train. My lord, in the process of the discussions in the end, my lord, I had omitted to say one thing relating to, my lord, the second proposition.
Where is that note? Who was that note? 2-page note. Really?
So, my lord, we had moved on a little bit, my lord, but may I, in the process, my lord, I omitted to say one thing I wanted to say under proposition B. Proposition B is that uncanalized, unguided powers, my lord. And relating to that, my lord, our case is that it is not uncanalized and not unguided because the decision has to be taken on the recommendation of the Reserve Bank, which is the acknowledged expert in the country on monetary policy.
That's what the learned attorney also said.
Lordship. Now, in aid of this, my lord, I am just giving your lordship the paragraphs. I am not going to read it out. In aid of this, my lord, the judgment in Peerless versus Reserve Bank, the citation, my lord, is 1992 2 SCC 343. 92 2 SCC 343. Paragraphs, my lord, 30.
1992.
2 SCC 2. SCC 343, and my lord, it is at item number 4 of my compilation. And my lord, all I want to refer to is paragraphs 30, 36 and 38. For the proposition that your lordships have recognized that that Reserve Bank of India is the expert as far as this area is concerned. So therefore,
It is also reiterated by my learned brother.
yes, my lord, in internet, and my lord, it has also been reiterated, my lord, in a one other very important recent judgment, where, my lord, the it's called, my lord, small scale industries, etc., and that was arising out of, my lord, the COVID situation, where, my lord, somebody was saying that RBI should give these benefits, etc. There also, my lord, this has been dealt with in extenso. I will trouble your lordship with one or two passages in a while, my lord. But all I want to point out is that it is acknowledged that this is expert, that RBI is the appropriate expert in the field. So therefore, it is on expert advice and therefore it is uncanalized. This is one. Number two is, my lord.
That is what Mr. Chidambaram also says.
Yes, my lord.
RBI is the one who has to do everything with currency.
That's correct, my lord. But therefore, if the recommendation, if the section provides for a recommendation by that body, it cannot be uncanalized, my lord, and therefore unconstitutional. Here, my lord, the challenge was to the constitutionality of the section. The second thing I want to point out, my lord, is that my learned friend's case is that the section should be read as some series, not one.
Any means
some.
one or some, not all.
Not all. Now, my lord, I have not been able to, my lord, figure out how it is guided as far as some is concerned, but unguided for all.
No, his submission is an alternative.
Yes,
He says that if you don't read any to be one or some,
yes,
then it will have to be construed that the power is unguided,
Correct.
unanalyzed, and therefore liable to be struck down on that ground.
right,
And if you want to save it,
yes.
then you have to read.
Then you have to read it as some, correct, my lord? Now, suppose that that argument is accepted and your lordship says some, then in what sense is it more guided? Because, my lord, no other guidance is given.
That Mr. Attorney General has also
Yes.
said that if we accept that
Yes,
out of, you also said yesterday,
yes, yes,
out of 20,
yes,
we can do 19,
yes.
but not the 20th one.
That's correct, my lord. And I don't find any extra guidance if it is interpreted as some. So, my lord, that's all I wish to add as far as the second proposition was concerned. My lord, I was actually on the third proposition. That third proposition is that there is no procedural lapse. My lord, kindly now, I'll come to the question of judicial review of the decision itself in the fourth proposition. The third proposition is there is no procedural lapse. Because if there is procedural lapse, my lord, certainly judicial review lies. No doubt about that. Now, for that purpose, my lord, your lordship has already seen that my lord, there was a letter from the state, from the central government on the 7th. We have disclosed it in our affidavit.
Have you placed that letter also on record?
No, the letter is not on record, but my lord, substance of that letter is on record. Secondly, my lord, on the 8th, the board, the central board met, decided to, my lord, recommend, and on 8th, my lord, it went to the cabinet and the cabinet took a decision. Now, now, my lord, here the only question is, was the procedure under 26 followed? And that obviously has been followed. Arguments that it was hasty, etc., may be made in respect of the decision. But, my lord, the procedurally, my lord, the procedural mandate of the section has been followed.
Yes.
And the only other point relating to procedure was quorum. My lord, I have checked up again. My lord, I again say, my lord, my learned friends did not take a categorical stand in their plea that there was no quorum. My lord, your lordship may, I'll show that, my lord, in the affidavit if necessary. But number one, we had categorically taken a stand that there was quorum. The page numbers in the existing affidavits is page 21 of our compilation and page 33 of our compilation. So the 33 is the first affidavit and the 29 is, 21 is the second affidavit. In both of it, we said that the requirements of regulation 8 and 10 have been followed. Now, regulation 8 is the one which deals with quorum. But my learned friend said that this is not a correct plea. You have not made a full statement. So, my lord, we have today, my lord, affirmed an affidavit. Okay. Give me a copy. So, my lord, we have now just a 2-page affidavit to reaffirm what has been stated in the existing affidavits, my lord. And here, my lord, we have extracted the regulation also.
But filing the affidavits at this stage, Mr. Gupta,
Yes, my lord. Your lordship is right, my lord.
at this stage.
It may be taken or not taken, my lord. I am doing this because, my lord, I don't want this point to remain in the air at all. If your lordships don't want, my lord, I will not file.
All right, take us what
Yes.
you want.
So here, my lord, we have first of all said in para 3 that the answering respondent has filed affidavits dated so and so, which may be read. Then, my lord, 4 is the composition of the board. This is section 8(1) of the RBI Act. The board will consist of the central board, a governor, and not more than 4 deputy governors to be appointed by central government. B, 8(1)(b), 4 directors to be nominated by the central government, 1 each from the 4 local boards as constituted under section 9. C, 10 directors to be nominated by the central government, and D, 2 government officials to be nominated by the central government. Now, this is the composition of the board. Then comes the regulation. The regulation is the next paragraph, and it is part of Reserve Bank of India General Regulations 1949. Now, my lord, there is some doubt as to whether the copy of this is available in all your lordship's files. Is there? Oh.
There, Mr. Chidambaram has already referred to it.
Yes, it was given, but my lord, in the morning we were checking up, my lord, they were thinking that perhaps one of your lordship's files did not have that. But whatever it is set out here. So your lordship doesn't have to go to that now. 8(3), regulation 8(3) said that 4 directors have, so the quorum is 4, of whom not less than 3 shall be directors nominated under 8(1)(b), 8(1)(c) and 12(4). 12(4) is just, my lord, temporary casual vacancies, my lord. It's not very important. Shall form a quorum. So, my lord, 3 have to come from 8(1)(b) and C and 12(4). Now comes para 6. On the 561st meeting of the Central Board of the answering respondent was held on 8/11 and business was transacted therein with the requisite quorum. During the said meeting, apart from the then governor and 2 deputy governors, 1 director nominated under section 8(1)(b) of the RBI Act, 2 directors nominated under 8(1)(c) of the RBI Act, and 2 directors nominated under 8(1)(d) of the RBI Act was present. So, my lord, the requirement that 3 of them should be from 8(1)(b) and 8(1)(c) is met.
There were 8 directors.
Yes, it was not 4, it was more than 4. Now, my lord, I have not disclosed the names, my lord, for various reasons. As far as I am concerned, my lord, the court may not want to look at names because the point is not names. The point is only, my lord, that the quorum requirement was fulfilled. So, my lord, this
The requirement of the regulation was complied with.
Complied with. And there is also a section 8, subsection 5, which says that no decision will be held to be vitiated because there are vacancies in the board. So, my lord, the fact that some of the posts was vacant doesn't mean that a decision taken by a central board will be vitiated. That is section 5. And, my lord, their affidavit says that we don't know. Now, that's not a plea, my lord. The pleading relating to this is at page 10 of my lord, the affidavit which my learned friend has been placing. And all it said was that the central board was 7 short. Only the minutes of the meeting will reveal how many directors falling under categories 8(1)(b) and C actually attended the meeting. So, my lord, there is no plea that there was a lack of quorum. My lord, when a person, my lord, challenges action, if there is a fact to his knowledge that affects the action, he makes a plea wherever the evidence may be. After having made the plea, my lord, he can say that the evidence is with the other side, produce it. But here, my lord, there is no plea at all. So therefore, my lord, I respectfully submit that this point also was a fishing, my lord, expedition as far as my learned friend was concerned. Now, my lord, I come. So therefore, no procedural lapse. Now we come to the decision itself. Whether, my lord, there will be judicial review of the decision, namely the recommendation.
He also agrees that while exercising our powers under judicial review,
Yeah.
we cannot examine the correctness of the decision. When Tata, right from Tata Cellular, it is a consistent. We can only examine the correctness of the decision-making process.
Correct. But, my lord, there is now a submission, and that submission, my lord, is supported by some authority. I am not saying, my lord, that it is a submission in the air. That the proportionality principle and the Wednesbury principle should be applied. Now, I have to make a submission relating to that. My lord, 2 of your lordships, my lord, have participated. Have participated, my lord, in other benches where the question of application of proportionality has been considered in the context of Reserve Bank of India. So, my lord, I will have to, my lord, make a submission relating to that. One is the internet judgment, and the other is, my lord, Akshay. Your lordship, Justice Nagaratna was in it. So, therefore, I now come to, my lord, the decision itself. My lord, now the challenge is to the decision itself. The decision is the recommendation and the decision of the cabinet. Now, my lord, when a section or whatever provision says that a procedure has to be followed, the procedure is X, the court checks and it's very simple. Have you or have you not followed the procedure? When the decision is a discretionary decision, the court cannot say that this decision is wrong. It then, my lord, applies only certain peripheral tests. And these, my lord, some of these tests, my lord, are the Wednesbury principles. Now, my lord, some proportionality principles, etc. This is under the category of whether discretion has been correctly exercised or not. The decision itself is not in my lord, in review. The process is under review. That is, my lord, the standard, my lord, submission. Now, my first submission, and before I do that, my lord, may I just say that the objective stated, the 3 objectives your lordship recollects, my lord, fake currency, black money and terrorism. 3 objectives stated. The measure is demonetization. My lord, there is obvious nexus. There is no question about it. With that in mind, my lord, my first submission is that the decision, judicial review of such a decision should not be done, my lord. And that is, my lord, supported by a long line of authority, that because it is an economic policy decision, therefore judicial review is not to be gone into. Now, my lord, I have also already, and I'm only confining now to RBI cases. My lord, in general law also, my lord, there is R.K. Garg, there is Sitaram Sugar. So therefore, my lord, the proposition is that when it is an economic policy measure, unless it is found to be unconstitutional, one would not want to go into it. Now, my lord, I am focusing on those cases which are RBI cases because they are economic policy measures. I have already shown your lordship Kuruvilla. I have given your lordship, my lord, the reference to Peerless. These two, my lord, are the parent cases as far as RBI is concerned. But I now want to show your lordship, my lord, a recent judgment, that is the small scale industries, and which I have, my lord, included in item 7 at page 215 of, my lord, the compilation. And if your lordship will kindly permit, because, my lord, the question is not that the court should be kept away from these matters. There is a reason why the court stays away from them. So the citation is, my lord, 2021, volume 8, SCC 511. And in my compilation, my lord, it is at 215. 2021, volume 8, SCC 511. And my lord, I would draw your lordship's attention, not place the whole lot, from paragraphs 59 to 77 is the relevant portion. 59 to 77. And I'll place, my lord, only 4 paragraphs. '59 starts at, my lord, page 567. And it starts with this preface. The lordship has page 271. While considering the aforesaid submissions and relief sought, the scope of judicial review on the policy decisions in the field of economy and economic policy decisions and/or policy decisions having financial implications which affects the economy of the country are required to be considered. So that's the heading. Then, my lord, come straight away to 69. After, my lord, setting out, discussing, my lord, the judgments, and one of those judgments, my lord, actually had taken into account the Metropolis Theatre judgment, which the learned attorney, my lord, showed your lordship yesterday. Having, my lord, set out all the judgments, it comes to, in paragraph 69, page 570. What is best? So this is the rationale, my lord. This is the rationale. What is best in the national economy, and in what manner and to what extent the financial packages are to be formulated, offered and implemented, is ultimately to be decided by the government and RBI on the aid and advice of experts. The same is a matter of decision exclusively within the province of the central government. Such matters do not ordinarily attract the power of judicial review. Ordinarily, they do not. Merely because some class or sector may not be agreeable and are satisfied with such packages, the court, in exercise of powers of judicial review, do not ordinarily infer with the policy decisions unless it is faulted on the ground of malafides, arbitrariness, unfairness, etc. There are matters regarding which the judges and lawyers of the courts can hardly be expected to have much knowledge by reason of their training and expertise. Economic and fiscal regulatory measures are a field where judges should encroach upon very warily, as judges are not experts in the matter. The correctness of the reasons which prompted the government in the decision taking one course of action instead of another is not a matter of concern in judicial review, and the court is not the appropriate forum for such investigation. Well, in this context, policy decision context, Millard, in other matters of judicial review, Millard, it will become relevant, Millard. The proportionality principle may be given full rein. I am saying, Millard, that when it is economic policy, judicial review of economic policy, you cannot give full rein to the Wednesbury principles and the proportionality principle. I'll come to that. But let me finish, Millard, here. The policy decision must be left to the government, as it alone can adopt which policy should be adopted after considering of the points from different angles. In assessing the propriety of the decision of the government, the court cannot interfere even if a second view is possible from that of the government. Then 72. Legality of the policy and not the wisdom or soundness of the policy is the subject of judicial review. The scope of judicial review of the government policy is now well defined. Courts do not and cannot act as an appellate authority examining the correctness, stability and appropriateness, nor are the court advisors to the executives on matters of policy, which the executives are entitled to formulate. Government has to, 73, has to decide its own priorities and relief to the different sectors. It cannot be disputed that the pandemic affected. However, at the same time, government is required to take various measures, etc., etc. Even the government suffered lockdown. All this is not necessary. That's in the factual way.
Of that case.
Yes. Then, so no writ of mandamus can be issued. Then C-Millard 74 is important. No state or country can have unlimited resources, etc. That is why it only announces financial to the extent feasible. The court would not interfere with any opinion formed by the government if it is based on relevant facts and circumstances or based on expert advice. It is not normally within the domain of the court to weigh the pros and cons or to scrutinize it or test the degree of its beneficial or equitable disposition for the purpose of varying, modifying, annulling, based on however sound and good reasoning, only where it is arbitrary and violative of constitutional, statutory, or other provisions of law. When the government forms its policy, it is based on a number of circumstances, on facts, laws, including constraints based on its resources. It is also based on expert opinion. It is dangerous if the right para 70 kindly come to 76. It is a cardinal principle that it is not within the legislative domain of the court, legitimate domain of the court, to determine whether a particular policy decision can be served better by adopting any policy different from what has been laid down, and to strike down as unreasonable merely on the ground that the policy enunciated does not meet with the approval of the court in regard to its efficaciousness for implementation of the objects and purposes. With the limited scope of judicial review affecting the economy or its financial implications, the relief submissions have to be considered. So, my lord, I am reading this because now, my lord, I would like to make a submission as to how this squares with the Wednesbury principle or the proportionality principle. Lordship will consider first the Wednesbury principles. Wednesbury principles, to the extent which is relevant to this case, is relevant considerations, irrelevant considerations. The first two, fettering discretion, acting under dictation, is not relevant, and nobody has alleged that it is so unreasonable that a reasonable person will not ever do such a thing. So therefore, my lord, those three are Wednesbury principles which we are not concerned. The allegation is relevant considerations, irrelevant considerations. Now, my lord, in an economic policy matter, the first problem is relevant how? Economically relevant or legally relevant? Now, my lord, economically relevant factors to an economic policy decision are very wide. It cannot possibly
have to be left for the expert.
has to be, my lords, for the simple reason, my lord, that even experts do not agree sometimes.
At the most, what we can examine is as to whether legal compliance is there or not.
Yes. So the classic case is, suppose a license for exporting is to be given to somebody, and somebody goes and the decision-making authority says, no, you belong to such and such caste, I won't give you a license. Now that's a legally irrelevant consideration. But my lord, if he refuses the license for some economic reason, then my lord, that becomes very difficult to test against Wednesbury principles. Number one. Then, my lord, come to the proportionality principle. Now, the proportionality principle, my lord, your lordships have summarized, my lord, in several judgments. Now it is clear that there is a fourfold test. Your lordships Akshay judgment also, my lord, talks about fourfold test. First, let me, my lord, enunciate the fourfold test and then see whether it can be applied to policy decisions as well. The fourfold test is, number one, there has to be a legitimate goal. So the goal here is the objective, namely black money, etc. Then, my lord, suitable or rational connection must be there between the measure and the goal. Now, these two, my lord, are normal legal tests anyway. If there is no nexus between the objective and the measure taken, then, my lord, on general principles also, my lord, it will be, your lordships will interfere. But the third one, look at the third one, my lord, must not be any less restrictive. There must not be any less restrictive but equally effective alternative. Now, my lord, actually, the heart of the proportionality principle is in the third.
This you said?
Sorry, my lord. There must not be any less restrictive but equally effective alternative. So, my lord, if there is an equally effective alternative which is less restrictive in the sense that it interferes less with a person's choices, let us say, then the proportionality principle is attracted. Now, this is the heart of the proportionality principles, my lord. The first two is only a lead up because the first two is always there in a legal framework. This, my lord,
It is a modern force.
207 in internet.
In internet, quite right. I'll give the citation also. Your lordship's judgment, my lord, Akshay, I'll give that citation also. To
And the press note of the
3 SCC 694. Is 2016 7 SCC 353. Justice Sikri, my lord, based on, my lord, academic texts also, my lord, very famous book by Aharon Barak, spoke about the proportionality principle in the context of, my lord, the fixation of fees in medical colleges. Now, and the fourth test is whether so the third one I have said, my lord, that it must be the least restrictive of the options, and that the impact should not be disproportionate. So these are the four tests. Now, what I want your lordships to, my lord, consider for a moment is that this third test, which is the heart of proportionality, how is that going to be applied in to its fullest extent in an economic policy measure? Because what you are saying is, these are the four possible economic measures. This one is the least restrictive. Have you taken it, or have you taken something other than that? Well, that becomes a direct review of all policy options and a decision by the court that this is the best option. So, my lord, full-blown application of the proportionality test is, in my respectful submission, not to be done in the case of a decision on economic policy. Now, why have your lordships, my lord, in the two judgments that I have seen, why have your lordships, my lord, applied that test? Because in both cases, my lord, there was a question of violation of fundamental right, 19(1)(g). And 19(1)(g) brings with it, my lord, question of reasonableness, has to be considered. In considering the question of reasonableness, proportionality is sometimes used, and that is the context in which your lordship said, because any policy, any decision, if it is unconstitutional, my lord, will certainly be subjected to judicial review. But whether it is an abuse of discretion, that will, my lord, be a different thing altogether. So, my lord, in both the two cases, Internet and Akshay Patel, we find that there was a banning of a particular situation, and the question was, did this take away 19(1)(g) rights? And, my lord, if I may, my lord, arguing before a learned judge who has delivered a judgment as to what might be the scope of that judgment, my lord, is otherwise, my lord, to a layman, my lord, it is an unheard of thing. But, my lord, we do it because, my lord, we are following a discipline and an exercise in court. So, my lord, this is an exercise which your lordships make.
Para 224 specifies as to why.
Exactly. Exactly, my lord. Paragraphs 223 and 224. says that you have not been able to establish any nexus.
We have not been able to place any material.
Any material on what? On the relationship between your objective and the measure. So the measure is to stop all VC exchanges from operating. You have not stopped VC currency. You have not stopped anybody who is actually trading in the VC currency. You have only stopped the exchange. And you are saying that this is for the benefit of banks, which I am and the finding is that not a single bank has suffered any loss. So the so-called object.
Sorry to interrupt, just to light a vein. I think your lordships correctly banned the VC exchange after what happened in America 10 days ago. The FTX exchange collapsed and billions were wiped out. Though VC currency is there, though VC trading is there, the exchange was, the ban of the exchange was correctly struck down because they had not considered the pros and cons. So,
No, not only that, actually what happened was 2 times bills were introduced to ban cryptocurrency.
Yes, yes,
But the parliament did not have the mind to ban cryptocurrency, number one.
yes.
Number two, the transaction through banking channels were allowed for people with cryptocurrencies,
Yes.
but not cryptocurrency exchanges.
Yes.
In the lighter vein, I was telling my brother, it was from VC to PC.
therefore, Milad, you can't brush aside the reasoning by saying you must have material to show why now, Milad, it's more material will be collected. They don't allow cryptocurrency in banks anymore. Cryptocurrency is not a medium of transacting money matters in the banks. Currency, if they want to ban the exchange, they must have material. Your lordship said there is no material to ban the exchange. But then they will collect material now. And I'm sure they will.
So,
To me, it should be done. But you have to justify it before you ban the VC exchange.
yes, but my point is, Milord, that judgment, Milord, did not go into that third exercise of Milord looking at different policy options and saying this one is less intrusive. Even though, Milord, because it's a fundamental rights case, it might have done so, but it didn't. Internet is not based on that kind of reasoning. My respectful submission is that in our case, there is no challenge to the decision on constitutional grounds. Therefore, Milord, the proportionality principle should only be applied to the extent which the attorney's note also suggests, Milord, that there should be nexus between the objective and the method. That's all. Beyond that, to take it would go against the run of play as far as economic policy measure decisions are concerned. Because then, how would your lordship, Milord, reconcile the older judgments with proportionality principle? I respectfully submit. Your lordship will consider that. So this, Milord, is my first submission relating to the judicial review of the decision. Being an economic policy measure, your lordships would not review the decision, Milord, judicially. That's one.
See, it is only on the merits. The court will not go into the merits of the decision.
That's right.
But it can always go into the manner in which the decision was taken.
Yes, yes. That
Two things are totally different.
it could.
Because it's an economic policy, the court cannot fold its hands and sit.
But
Merits
yes,
of the decision, it is for the government in its wisdom. It knows what is best for the people
lordship,
or ought to know.
lordship.
But while taking that decision, what was the material on record, consideration of relevant considerations, not taking into
In any policy
Learned
decision,
AG has also relied on Gwalior Revan and Birla
Yes.
Spinning in support of this
yes,
earlier judgment.
yes, yes, correct, Milord. So therefore, Milord, I respectfully submit, Milord, that the proportionality principle also cannot be applied to that extent. Now, the second aspect of judicial review of this decision, Milord, is the question of burden. My learned friend was brushing it aside, Milord, yesterday, that the burden doesn't matter. But, Milord, there is Constitution Bench authority, which is still not stated to be incorrect or anything, that the onus primarily lies on the petitioner. If they are not able to produce evidence in support of their plea, they cannot require the respondent to show that the plea is untenable. Milord, this is Constitution Bench, Milord, 1966, 1 SCR 430, Ramkishore Sen. Milord, I'll hand up that judgment, Milord. It's not in that compilation. Just for the record, Milord, I'm not placing the judgment also. It's a fairly well settled proposition given. Oh, they have taken the book. Give me a copy. Have you got a copy? Yeah, 1966, 1 SCR 430. 430. Milord, this was one offshoot of the Berubari case, where, Milord, a dispute, the petitioner said that the correct maps were not being produced. In this context, Milord, I'll just give your lordship the paragraph in a minute. I'm sorry, Milord, I'm just having a slight difficulty.
Here it is difficult to find paragraph.
Yes, unless it is bookmarked, Milord, it becomes very difficult. I'll just keep. Yes, the paragraph number in the SCR is para 14.
Here there are no para numbers.
No
Yeah,
paragraphs.
it doesn't have a para number. Oh, they've introduced it again, Milord. No, they have again, Milord, given me an online web, SCC online web edition. See this problem. You please don't do this. Please give me the SCR citation. Never do this. Anyway, Milord, it starts with the learned judge was not impressed by these arguments, and we think rightly.
Page 441.
Page 441. Milord, deeply obliged. Justice Gajendra Katkar's judgment, the learned judge was not impressed with these arguments, and we think rightly. It is true that the official maps in regard to the area with which we are concerned are not easy to secure. It is not, however, possible to accept the theory that they have been deliberately withdrawn from the market. In fact, during the course of the hearing, the appellants themselves produced 2 maps. Besides, as the learned judge points out, when the case was first argued before him, the learned Attorney General appearing for the respondents produced most of the maps, and the learned judge directed that they should be kept on record to enable appellants to take inspection. Under these circumstances, we do not see how the appellant can complain that the respondents have suppressed evidence, or can ask the court to hold that the onus was on the respondent to prove that the relevant provisions of the Amendment Act can be implemented. The onus, now this is the point, Milord, the onus must primarily lie on the appellants to show that what is attempted to be done by the respondent in pursuance of the provisions of the Act is illegal or unconstitutional. If they are not able to produce evidence in support of the plea, they cannot require the respondent to show that the plea made by the appellant is untenable. Now, this is happening, Milord, every day by a casual argument that show us, we will find out. It's happening every day, Milord. An argument is made, oh, I don't have this document, but you'll produce it, then we'll see. It's happened in the case of the quorum point also. But the law still remains this, Milord, and I respectfully submit, Milord, that in a case like this, it should be applied. Now, the third aspect, my lord, on the merits, my lord, I just want to make a very brief submission, my lord. We can't go into all the aspects which my learned friend's affidavit deals, because an overall view must be taken of the matter. Now, before I go there, my lord, I just wanted to indicate what were the essential elements of this decision. First of all, my lord, full value is to be given for all legitimate currency. That's number one. No currency is taken away. Full value is to be given for all legitimate currency held by everybody. Of course, if it is being held illegitimately, then there is no question of, my lord, taking that into consideration. That's number one. Number two is all non-cash methods of transacting are still available during that period. So, my lord, credit card, bank, check, everything, all available. And third thing is this, my lord, that there were steps to contain the use of cash. One of the purposes of this exercise was to actually try to control the use of cash, curtail it. And that, my lord, we have mentioned at page 38 of our compilation affidavit, my lord. I don't have to take your lordship there, but this is, my lord, the position which has been stated. Now, therefore, if these are, my lord, the basic elements of this decision, then, my lord, to quibble over matters like what about those notes which were printed 3 days back? Now, what happens? On the one hand, if the nation, if the currency printing presses were told, you stop printing these notes, well, the message is absolutely loud and clear. Number one. Number two is, what will happen if I do that? The government will lose some money. There will be some expenditure involved in it. But in order to achieve the aim, that expenditure, my lord, is a pittance. So, my lord, arguments like it's absurd to print a note today and demonetize it tomorrow. My lord, this is not an argument of law. It's not an argument of law. My lord, it's something which people may raise, but not, my lord, in a court of law. In fact, my lord, what we have done in one of our affidavits is to show that elaborate measures were put into place to remonetize the economy, if I may use that expression, my lord. These elaborate measures, my lord, are contained in paragraph 11 onwards, 11 to 17 of our first affidavit. One. My lord, I'm not going to take your lordship through the whole thing. I just want your lordship to glance at the depth and, my lord, the extent to which, the detail to which, my lord, this whole exercise went. My argument being that if from first day elements were put into place with such great care, then can you say that this was a thoughtless decision? Page 40,
The affidavit.
page 41, it starts. Bottom. This is my compilation of affidavits filed by the Reserve Bank of India. 4 of them are there. Affidavits. There is one compilation of notifications and other instruments, and there is one compilation of affidavits, and now there is a compilation of judgments,
Oh, there is a compilation of affidavit, not this.
like this.
That document, it contains 4 documents.
4 affidavits.
4 documents.
No, 4 affidavits.
Yeah, counter affidavit, additional counter affidavit, etc. It reads there.
Yes, yes.
Compilation of affidavits.
Yes. Pages 1 to 133.
1 to 133.
Yes, that Then 42, my lord, first starts with the transactions which were permitted, making payment to government hospitals, railway counters, milk purchase, etc., petrol, diesel, etc., etc. Your lordship knows, my lord, that there were certain categories in which this was misused, by the way, very badly misused, my lord. Every opportunity which was given for genuine purposes was misused. And how was it misused? The money actually sometimes came from some other source. The person may be in hospital, but they are, my lord, pushing in funds from somewhere else. Petrol station, same thing happened, my lord. They were pushing in funds from somewhere else. So it's misused. That's not the issue here at all. Question here is, my lord, that this is the level of preparedness of the government and RBI in the matter after the decision is taken. Then 43, allowed to be exchanged with bank branches up to November 24 and to at issue offices of the answering respondents up to 30th of December, etc., etc. Well, I am not going to read the whole lot, all the way up to para 17, and some of it is mind-boggling detail, my lord, because it talks about banking correspondence networks, etc. Things which I am seeing for the first time, my lord. ATM network, network reach, etc., etc., everything. Now, the point is only this. If I am in such readiness and the government is in such readiness to deal with the situation, then, my lord, to say that it is thoughtless is not correct. And we have also made a statement, and the government has also made a statement, that whenever a problem arose, changes were made to the existing system again. There were control rooms in which people could go and say that this is the problem I'm facing. No money should be lost in the process. And, my lord, your lordship has heard the PSC saying that our money, there was no channel for getting back our money. That's not correct. If that issue has to be gone into, my lord, we will demonstrate that they had options. For instance, my lord, one option, if suppose there is a approved account. Now, this is, my lord, the nature of the situation. Now, to say that you didn't take into account anything, that in my respectful submission, does not lie. Now, temporary hardships were there. Temporary hardships, my lord, are, if I may say so, my lord, without sounding too pompous, it is really an integral part of nation building also. My lord, there is a lot of consensus that everybody is prepared for some hardship in order to achieve that objective. There was a lot of unanimity on that also. Some people didn't agree. That's all right. Now, some hardship may not have been anticipated also. But we had in place, my lord, methods, systems by which, my lord, if a problem arose, it could be solved. Now, my lord, these small things, my lord, should not, my lord, come in the way of a legal argument, my lord, that the remonetization was not planned. It was not, it cannot possibly be planned in the sense that you take out X amount of currency today and you remonetize on the next day. It's not possible. That would involve, my lord, preparing for demonetization on a big scale beforehand. It can't be done. And my learned friends, my lord, have always been emphasizing this 86% aspect. My lord, 86% is a published data. Year after year, it has been published. Now, Central Board is taking a decision. The central government is taking a decision based on public data. Now, can it be said that show me that you have actually written down somewhere that I have considered that this is 86%? The first thing which strikes anybody on demonetization is that the currency will get sucked out of the market, of course. But there is a process by which it will come back into the market. So, my lord, I respectfully submit, my lord, that the kind of arguments which have been put forward on this question, my lord, respectfully should not be gone into. And anyway, my lord, they have not established any legal grounds for saying that relevant and irrelevant considerations have been taken into consideration.
Gupta, since you are on this affidavit,
Yes, yes.
where is the amendment with regard to compliance with regulations?
Yes. My lord, in this affidavit, my lord, it is at page 33, I think. Let me just.
In the earlier affidavit, it is at page 21.
21. Yes. And in this one, my lord, I think it is 33. Just a minute. 33. No. Huh? 33 is not telling. But I know the paragraph. Milord, just give me 1 minute, Milord. I'll just now point out. It's at page 49, Milord. It's more or less the same thing which was stated in the
earlier.
So it's in part of para 21, but at page 49 in the middle,
It's in compliance with.
yes, the procedure for conducting the business of the central board has been provided under the general regulation, while procedure for holding meeting has been provided in regulation 8, has been prescribed regulation 10 in compliance with the provisions of section 26, read with regulation 8 and 10 of the regulations. Then the meeting was held on 8th of November, etc. etc. Now, Milord, I have, Milord, said what I wanted to say about judicial review of the decision itself. Now I come to, Milord, the SBN Act, the new act. It's here somewhere. Now, the first thing to be noted about the act is, Milord, statutorily now, the notification has been affirmed. So now we are no longer, Milord, in a realm where the Parliament did not have an opportunity to consider the decision taken by way of that notification. My learned friend has already, Milord, made that point. So therefore, it has been now considered and affirmed. That's number one. Number two is, Milord, this arises out of Mr. Diwan's arguments, Milord, that one gentleman who he says is an NRI had kept some money in India and he had gone abroad. He expected, Milord, please note that, Milord, he expected that the announced deadline will be extended. Milord, this hard stop argument that suddenly on 30th you did this is not correct. It was always known that it would be 31st. What he's saying is that I thought you will extend it. You decided on the last minute not to extend it. That's a very, very different thing to say. What was it that persuaded him not to take any steps till then in the hope that it will be extended? Anyway, Milord, that's a different thing, Milord. I'll come back to that. Now, 3 is very important. 3, Milord, says statutorily that after 31st of December, it will cease to be legal tender. And the liability of the Reserve Bank under section 34 and the guarantee of the central bank, which is all, both of which are absolutely necessary for the purpose of it being legal tender, that is gone on that date. Milord, it is important to recognize that statutorily section 3 put an end to, Milord, the possibility of, Milord, these notes being given exchange value. One waiver was given, and that is section 4. Milord, if your lordship has section 4, Milord, I'd like to, Milord, take your lordship to that. Milord, I think, Milord, it was put into a compilation by
In 2-3 compilations.
Yeah, there are 2-3 compilations. Milord, it's also in the textbook, by the way. The Bear Act also has it, Milord. I mean, some Bear Act publications have it.
Latest is in the Learned Ages compilations.
Yes. Now, Milord, this act, as your lordship has seen, specified Banknotes Cessation of Liabilities Act 2017. That's why, Milord, we are using the short form SBN. And Milord, all the officers refer to this as SBN. That's how they call it. Now, may I place 3 and 4 for a minute? On and from the appointed day, 3, notwithstanding anything contained in the RBI Act of 1934 or any other law for the time being in force, the specified banknotes which have ceased to be legal tender, in view of the notification of the Government of India and the Ministry of Finance dated 8 November, issued under subsection 2 of section 26 of the Reserve Bank of India, shall cease to be liabilities of the Reserve Bank under section 34 and shall cease to have the guarantee of central government under subsection 1 of section 26 of the said Act. So that's the end. Now comes 4, exchange of specified banknotes. notwithstanding anything contained in section 3, the following persons holding specified banknotes on or before 8th of November 2016 shall be entitled to tender within the grace period with such declarations or statements at such offices of the RBI or in such other manner as may be specified by it, namely. So what are the categories now? 1. A citizen of India who makes a declaration that he was outside India between 9th November 2016 to 30th December 2016, subject to conditions as may be specified by notification by the central government, or such class of persons and for such other reasons as may be specified by notification by the central government. Fact is, of course, my lord, no further class of persons was notified by the central government under 412. So we are left only with a category of persons who are citizens who makes a declaration that he was outside. Let's see, he does not have to explain why he was outside. He doesn't have to say that I could not come back in, I was unable to do something, nothing. He only has to show that he was outside. If you do that, what happens, my lord? That follows from a notification. It's not in the section. That notification, my lord, is in this compilation of notifications. Yes. Okay. Finding all the other notifications.
Yes, Mr. Mukherjee.
I'm sorry, my lord, two things was done. As far as, yes, I think I have it, my lord.
That is also in Mr. Diwan's compilation.
Yes, my lord. No, all the DCCB ones are coming out. My lord, two, the notification provides, I'll just find it, my lord. The notification provided two things. As far as residents are concerned, there is a your lordship has found it.
Notification dated 30th December 2016.
13th December. I just opened it. Yes, 30th December. Yes, page 60. Yes, ma'am. So, may I just place that? In exercise of the powers conferred under clause B of section 1 of section 2, read with clause 1 of section 1 of section 4 of the SBN Act, the central government hereby specifies, in respect of citizens of India, referred to clause 1 of subsection 1 of section 4 of the ordinance, A, who are resident in India, the period ending 31st of March 2017. So if you were out between 9th and this end of December, then up to 31st of March, you will get to exchange your notes if he is a resident. If he is not a resident, that is if he is an NRI, then the period is even longer, it's June. But that is subject to the proviso that it does not exceed the amount specified in regulation such and such of the FEMA made under the provisions of the Management Act. Now, sum and substance of that proviso is NRIs are permitted to take out up to 25,000 and they are allowed to bring back 25,000. So the result of is, my lord, that if you are an NRI, you have this grace period, but you can only deposit 25. Yes, those are on record. My lord, the FEMA regulations, my lord, your lordship has the numbers, but I'll print it out, my lord, and give it to your lordship also. So the
There
question,
is no dispute on that. He also.
there is no dispute on that, quite right. Now, my lord, now come to 2, subsection 2. The Reserve Bank may, if satisfied. The Reserve Bank may, if satisfied, after making such verifications as it may consider necessary, that the reason for failure to deposit the notes within the period specified in the notification referred to in 3 are genuine, credit the value of the notes in his Know Your Customer compliant bank account in such manner as may be specified. And 3, any person aggrieved by the refusal of Reserve Bank to credit may make a representation to the Central Board of RBI within 14 days. Now, my lord, first question is section 4.1 unconstitutional for some reason? That's the first question. Because if it is constitutional, my lord, section 4.2 cannot extend those deadlines. This is the reason, my lord, why RBI received several applications. My learned friends note as the facts also, my lord. They received, my lord, hundreds of applications and they were disposed of. Some were allowed, some were not allowed. Now, they always, my lord, took the stand that we are only to verify as provided in subsection 2 if it comes within the periods mentioned in 3 and 4.1. Because that beyond that the statute is not permitting.
Your power is not beyond the notification referred to in subsection 3.
Exactly, my lord. Why? Because those sections and those notifications are law now, statutory law. Now, subsection 2 does not say that notwithstanding what is contained in 3 and 4.1, RBI can go ahead. So there's a complete, my lord, cessation of liability as far as 3 is concerned and a small waiver as far as 4 is concerned. How can the RBI go behind that and say that even if you don't fall within these 2 categories, I will still accept?
But prima facie, that doesn't appear to be correct.
Now, my lord, your lordship is right in one sense.
You please read subsection.
Yes, I'm reading, my lord. The Reserve Bank may, if satisfied, after making such verifications as it may consider necessary, that the reason for failure to deposit the notes within the period specified in the notification referred to in section 3 are genuine, credit the value of the notes to KYC accounts.
What is the notification? What is the date fixed by the notification dated 8th November 2016?
That is, my lord, 8th November was, my lord, first 24th November and up to 30th.
30th December.
30th, let's say up to 30th.
So the power could be exercised.
Yes,
If there is a failure
yes,
to deposit the amount
yes,
prior to 30th December,
yes,
and if the RBI finds the reasons to be genuine,
yes, correct.
but that power would be independent of subsection 1 of section 4.
Yes, my lord, it's not independent. My lord, let me just, my lord, no, my lord, what I'm saying is,
411
yes,
empowers the central government,
yes, to go beyond the first notification.
but 411 is only for the citizens who are outside the country.
Yes, correct.
Then clause 2
Yes,
empowers the central government to pass such notification for such classes that
but they have not done.
has not done it.
So therefore, we are left with,
Then subsection 2 is concerned,
yes,
it has to be read with section 3
yes, my lord.
independently without bringing in subsection 1.
No, my lord, it will have to take into account subsection 1 for this reason that the RBI, somebody will come and say that I was outside for 9th of India between 9th November and 30th December.
No. That is independent. It has nothing to do with the person who is outside India or inside India.
No, my lord, it is.
No. The Reserve Bank of India, the Reserve Bank may, if satisfied,
Yes,
after making such verification,
yes.
as it may consider necessary,
For the
the
reason for
Reserve
failure,
to deposit the notes.
deposit the notes within the period specified in the notification referred to in
Section 1.
section 3. That's the first notification. So if you have failed to deposit the notes by 30th of December
Are genuine.
and that there is
Are
a
genuine.
genuine reason for it, then you will, my lord, RBI will then exchange it. But the 4.1 says that even those have to be within these time limits.
No. 4.1 and 4.2 are independent of each other.
Well, that is the question. Can 4.2 be read independent of 4.1? RBI's stand is, my lord, that 4.2 is only to give effect to 4.1 because 4.1 says declarations and statements. Somebody has to check whether this person genuinely was out.
No, if 4.2
Yes,
was to give an effect to what is provided in 4.1,
yes.
then a reference to section 3 would not have been there.
No, it would be not, because 4.1 is also beyond the period of this, that section 3 notification. It's a grace period. It's referred to as a grace period. It is a grace period because there has been a failure to come within the notification referred to in section 3.
One.
In a bank account, and the bank account would give you credit for it. So there is, my lord, only those people who were outside who was told that they can now.
Gupta, according to you, 4.2 would be only applicable to the citizens of India who are outside India.
No, not outside.
Who went outside India.
Who went outside India and could not deposit within 30th December.
That's right. That is correct.
So that grace period is only applicable to them.
That's right.
But suppose if there are some Indian citizens
Yes.
who, for some genuine reasons,
Mhm.
could not deposit that amount by 30th of December,
Yes.
like the example which we gave it to you the other day.
Yes.
Somebody was in a coma or some housewife was not knowing where she has kept money and she has subsequently discovered it. And if such an application is made after 30th of December, but between 30th of March and 30th of June, whether you have considered such cases?
No. Because the condition is that he has to make a declaration.
According to you, it is only applicable to Indian citizens, either resident or non-resident,
Correct. Who are traveling.
who are out of India.
Who are out of India. Correct. Millard, the reason why this is not an unreasonable provision of law is because an adequate opportunity or a window has already been given under the existing first notification to arrange your affairs in such a way that your notes are not destroyed. And Millard, very wide arrangements. You didn't need to go there. You could authorize somebody else to go and do it also. So, my lord, care was taken to see that nobody's money is destroyed unnecessarily. All of us, my lord, got that opportunity.
Some of these statistics are given by the learned attorney.
Yes, my lord.
There is no page number there.
My lord, my,
In a note to which.
my lord, the learned attorney wanted to, my lord, show that to your lordship.
Series of notes.
Yes, yes.
That's last page that.
On the series issue, the third and the fourth
He
page.
wanted to show it, why don't
You lot would like to intervene now? I thought let.
My lord, this is what my learned friend wanted to address your
What he
lordship
left
on
yesterday.
afterwards. Now, my lord, the proposition is this, that everybody got a reasonable opportunity to exchange their notes. This included NRIs also. So, my lord, Mr. Malvinder Singh also had that opportunity for those 2 months, November, December, to exchange his notes. The reasonableness of this, my lord, section, therefore, is based on the opportunity which has been given. Now, question is it can this be a ground of challenge? That your lordships have said in the Jayantilal Ratanlal case, that this cannot be a ground of challenge, that a certain amount of time has been given and no more.
I think Mr. Adoni also referred
Has-
to some cases yesterday.
Yes, but this is in connection with the 1978 demonetization. And that judgment, your lordship has already got the copy, I think,
Yes, sir.
which is, my lord, citation is
1994.
1996, 9 SCC 650. And the relevant paragraph is para 10, which says, and I'll just read it, my lord, your lordship has been taken through it already, or your lordship has noticed it, my lord, when it was actually referred to by Mr. Diwan in the context of saying that it is already established by Constitution Bench Authority that cash is property.
300 days.
300, so, my lord, in this case, it was 19(1)(f).
1991, yeah.
Because then 19(1)(f) was still there. My learned friend wishes to extend this principle to 300A. Whether violation of 300A, my lord, my lord, makes it unconstitutional or not, my lord, that's another Pandora's box, my lord. Where, my lord, justice.
In any case, according to you,
Yes,
an opportunity, even if it is held to be a right to property,
yes,
still that right is not taken away since you have been granted a reasonable period to exchange the.
exactly, my lord. And I add only this, my lord, to that, to what I have just said, that it is up to a person to arrange his affairs in such a manner that they can avail of that opportunity. Lord, it is your duty.
So what would happen if on 31st, till the end of the banking hours, there was a long queue and many people had to return because the working hours came to an end?
My lord, if he is tendering it on 30th, my lord,
31st.
31st, my lord, he will get value.
No, their banking hours are there and there should be
No,
sufficient.
my lord, in those days, if your lordship recollect, and this is one marvel, I would say, my lord, bank officers worked 24 hours. Bank officers, my lord, held up this system at that point of time. Almost, my lord, they were the most important people in the country.
See, why we are saying this is, those who had these demonetized notes, they wanted to get rid of it. They were paying the laborers, the servants, everybody in the demonetized notes.
My lord,
And they had to go and get it exchanged in order to have a.
that is not legal.
No,
My lord,
happening.
it is not legal
That
after.
was the reality.
But
And
let-
they had to stand in long queues to
Let-
get their
let the-
notes
My
exchanged.
lord, the reality, if it is illegal, cannot be considered by a court, my lord.
No, that was declared illegal 2 months prior to that last date.
Exactly.
This is what you are suggesting.
Exactly, my lord. Because on the very
Therefore,
first,
even if there is a payment after that cutoff date, they are all illegal.
they are all illegal if it is in the demonetized note.
Ah.
Because after that date, my
No,
lord,
2 months is given only for exchange.
exchange
This is
only.
what you are suggesting.
That's right, my lord. That is what, my lord, the original notification itself said, and the notification has found place in this act. Now, everybody got that opportunity. If they gave it to somebody else to go and exchange, my lord, they were doing something illegal. What you could do legally is you have in your possession certain amount of currency. That currency, you or anybody authorized on your behalf will go to the bank and declare, this is my currency. So if you are going to give it to some other individual saying that it is your money, do what you feel like with it, then you are not doing the correct thing. You can go to the bank, declare it to be your own money and say that now credit my account, because it has to go into some account which is a authenticated account. Therefore, cases where, my lord, a person was unable to tender it on the
No,
31st.
this is what I was about to ask you. Is there any reported case where
Yes,
somebody was standing in queue and he was sent out because of the,
I don't think so, my lord. I'll check that out.
is there any reported case? No, forget the case of
That some people fainted because they had to. stand
Yes,
in the
my lord.
queue.
There were some unfortunate incidents like that. Yes. But that actually happened in the beginning.
Beginning, yes.
Yes, because, my lord, then there was some notes were, my lord.
Panic because of panic.
Yes, and those were happening in the ATMs where people were going there to withdraw cash. That was because, my lord, there was not enough cash.
Did not exchange after 12 or 12:30, the first few days, because they said we've only got so much.
much cash.
new
Yes,
cash.
yes.
And therefore, they were able to exchange only the first 100 people or so.
Yeah.
And then the 101st man had to return and come back.
Yes.
We have number of cases where you have to go twice, thrice for exchange. It happened in the
No,
first.
but what my learned brother is saying, is there a reported case
Hmm?
wherein a person went to the bank on 31st December and he was not permitted to.
I don't know.
My lord, nobody of that situation, my lord, has come forward, my lord, to the RBI saying this.
no, to my knowledge, whatever we have read from the newspapers, of
Yes.
course, we don't have authentic knowledge like you. There was no such case.
There was no such case.
No, my brother is
And
right
I just checked with my officer also.
that we have, you must tell us.
Yes, my lord, my officer says he will check up again.
According to whoever attempted.
Yes.
to exchange.
Was allowed, my lord.
Allowed.
If it was.
Even the other side, even Mr. Chidambaram was fair. He has not also said that.
I don't
He has
know
not said that.
Case where somebody on 31st was told you have come after office hours.
Officer.
No,
After bank.
He has also
I don't
not
think
said
so.
I
that.
don't know. It
Because
happened in the
virtually
first few days.
This
No,
2
that
months
was for
period,
withdrawal of cash.
Yes.
Limited cash
Ah,
available.
That was not for exchange, it was for withdrawal of cash.
No, for exchange also.
For exchange.
also.
Each bank had only so
maybe-
much cash.
Yes.
So they were only printing so much cash and they had to give it to the thousands of branches.
yes.
So they're limited cash. So if somebody came and exchanged 100 people have exchanged it. The 101st person may have has been turned away and he had to come back the next day.
Yes.
We have read newspaper reports that somebody had to go once, twice, thrice to exchange them
Yes.
because of limitation of cash.
Yes.
No, my lord, subject to correction, my lord, I'm checking up again. I don't believe, my lord, people were allowed to exchange old cash for new cash. They were, my lord, when they brought cash in, it was credited to their account. After that, my lord, by a different process, they could go to the ATM or whatever be the process for withdrawal of cash. They could do that, get the new notes. But it is not as if they took old notes in and were given new notes in return.
That's not correct. Well, I have done it. How do you buy things the next day? Old cash was given to the bank branch and up to, I think, 5,000 rupees.
24,000 and something.
They gave you new cash notes. Otherwise, how do you live for the first few days?
No, my lord.
No, there was certain.
Well, I will check up again, my lord. My impression is, my lord, that it did happen in that process. The bank gave
Anyway,
credit.
we need not go into
Yes,
this
we need
issue.
not.
That is not
We need-
just for a discussion.
So, my lord,
Please proceed.
Mr. Gupta,
Yeah.
you may not be correct because the notification dated 8/11/2015.
yes.
Paragraph 2(1) itself says.
Yes.
The specified bank notes of aggregate value of rupees 4,000 or below.
Yes.
May be exchanged for any denomination of bank notes having legal tender.
Yes.
Therefore, it is not, and then crediting it into the account comes 2.2, 2.3, etc.
Yes.
2.1.
Otherwise, how do we buy milk or vegetables?
Yes.
That actually may not be correct.
No. So therefore, my lord, my submission, if I put it, my lord, in one sentence, reasonable opportunity of exchange was given and it was up to persons to arrange their affairs so as to avail of that opportunity. And my lord, in this judgment, which your lordships decided in connection with the 1978, in paragraph 10, it was said that the argument was raised. They have, however, contended on behalf of the petitioner that even if it is assumed that Article 31 has not been violated, the time prescribed for exchange of high denomination notes was unreasonable and violative of fundamental rights. When the above provision of the Act is considered in the context of the purpose, namely to stop circulation of high denomination notes as early as possible, the above contention cannot be accepted, consequent upon the high denomination notes ceasing to be legal tender, and in view of prohibition of transfer of possession of such notes from one person to another. It was absolutely necessary to ensure that no opportunity was available to the holders of high denomination notes to transfer the same to the possession of others. At the same time, it was necessary to afford a reasonable opportunity to the holders to get these exchanged. However, if the time for such exchange was not limited, the high denomination notes could be circulated and transferred without the knowledge of the authorities concerned from one person to another, and any such transferee could walk into the bank on any day thereafter and demand exchange of his notes. In that case, it would be well nigh impossible for the bank to prove that such a person was not the owner or holder of the notes. Needless to say, in such an eventuality, the very object with which Demonetization Act sought to achieve would have been defeated, etc. So this is Constitution Bench authority, that a reasonable opportunity has to be given. If it is given, then there is nothing else wrong with it. Now, if that is so, my lord, this reasonable opportunity was given to everybody, including Mr. Malvinder Singh, who is an NRI. Even an NRI, if he had some money lying in India, he could have arranged his affairs in such a way, either by himself or by constituting somebody as an authorized agent, to come and get that deposited and exchanged.
For and on his behalf.
On his behalf also. There was a format by which, my lord, you can, my lord, ask somebody else to do it on your behalf. So if a person outside India needed to do it, it could have been done by somebody in India for them.
If it is in his
In the
locker.
locker.
If it is in his locker, you won't give the locker
Let-
key to him.
Now, my lord, so it gets.
Yeah, I don't think
Practical.
it's a-
No, my lord, most people were able to do it, my lord. This is not a situation where every last individual can be catered for. Now, if a person has left money in the locker and therefore he has no other method of accessing it but to come back to India. Now, my lord, why won't he come back to India? He wants his 1 lakh, it's some value to him, 1,50,000. Why will he not come back to India to comply with the law? The law says you have only got one opportunity. Come back within 2 months' time, get your money. It's not as if he has not been given an option. He's been given that option. In fact, in Mr. Malvinder Singh's case, my lord, we find that there is not a letter on record saying that I am unable to come, my money is lying there, etc., etc. So, look, this reasonable opportunity is long enough for a person to arrange his affairs.
See, this is all you are governing the public.
Want to lose his NRI status, for all we know. It might be more valuable to him than 1,50,000.
What was the time allotted to NRIs here?
Same as everybody else.
NRI, I think it was a longer period.
Longer period.
March 2020.
20th of June.
30th June.
No, no, my lord. It is
Not NRIs, I think those who are.
There is a distinction between
Uh-huh.
foreign citizens acquiring overseas citizenship of India.
No, not foreign citizens. It was only available.
NRI
It was only available to citizens of India.
30th March of 2017.
31st March 2017 for
for residents.
India.
For residents.
And 30th of June.
Ah,
for
30th
NRI.
June.
For NRIs. But my lord, what we are forgetting in the process is that NRIs had the same 2 months which everybody else had.
No, it was extended till 30th.
Of course, it was extended, but it doesn't mean they didn't have the original time. It is not as if their time starts from 1st of January 2017.
Yes, that is true.
They got a grace period.
They got a grace period. They got more time because they were able to show that they could not be in India between 9th of November and 31st of December. So it's a benefit given to them, but it has a cap. Why? Because under the FEMA, they could not have left with more than 25,000 and they couldn't have come back with more than 25. Now, if they were holding it in India, then, my lord, and it cannot be accessed by any person but that gentleman himself, then, my lord, he has to arrange his affairs in such a manner that he gets his value of his money within the time given to him. My lord, would your lordship, my lord, countenance an argument that I don't care what the law is, I'll go and check Yes, my lord. So, my lord, this is my submission. Two aspects only here. One is it is not unconstitutional. My lord, manifest unreasonableness does not apply because we have given a window of opportunity. Discrimination does not apply because he is some other category altogether. He claims he is some one individual who has some particular problem. Article 21 and Article 300A, my lord, is a long shot. Now I come to, my lord, the second point is whether 4.2 should be declared to be a separate standalone provision. There are two reasons I have given, my lord. I've given
What
one
is that you
reason.
said?
There are actually
Manifest arbitrariness or unreasonableness, you said.
manifest. It could be manifest unreasonableness.
How to define manifest
No,
arbitrariness?
my lord, your lordships have now.
How to define this? I don't
Very
know.
often, adjectives are used.
How to define
My lord,
this?
may I make a submission? Just deviating.
How to define?
Yes, my lord. Please.
When is very principle?
No.
We have
No, my lord, manifest unreasonableness must be on a higher level than Wednesbury.
No, how to define this?
My lord,
See, for you it may be manifest arbitrary, for me it may not be. How to define? What is the parameters for this?
there is no parameters. As of now, there are only.
Your impression may be different, my impression.
Absolutely, my lord. So ultimately, it will be a lordship's view which will prevail, my lord. My view won't prevail because somebody will
No,
challenge.
we
you.
too need some yardstick, no? Supposing if it is a violative of some principles of the
So, my
constitution.
lord, if I may
We
just,
understood.
just take 1 minute, my lord, on how this law has come to this state. Your lordship.
Just on some other.
No.
The English language is a minefield of, the English language is a minefield of problems. And all these adjectives are very often used to convey an emphasis. It's only an emphasis. Where you find that you kind of an yardstick, where you use the word a manifest, that means something doesn't require a demonstration at all.
Yes.
It is as easy for you to see. Palpably arbitrary. We all use kind of adjectives to apply an emphasis. So sometimes become difficult to go beyond a normative criteria. It's again a thinking on the subject. So courts do that very often. And we try to have a dialogue saying, please don't do that.
In fact, what the courts do sometimes, my lord, and they put it this way, that it may be difficult to draw the line, but I know what is on this side of the line and what is on the other side of the line. It's an instinctive kind of thing.
It's a matter of perception.
It is a matter of perception.
All right.
Now, my lord, the way this has come about, and I, with some seriousness, my lord, the way this has come about is this. Initially, Article 14 only said discrimination. Then, my lord, for administrative action, your lordship said unreasonableness and arbitrariness itself is Article 14. That was the International Airports Authority, etc. But, my lord, and this happened in different courts in different manners. My lord, in the High Court, my lord, in Calcutta, it immediately became possible to file a petition challenging a legislation on the ground of unreasonableness, saying that Article 14, according to International Airports Authority, includes this second dimension, unreasonableness. But, my lord, most courts, my lord, held back and said, no. That additional dimension of Article 14 cannot be used to strike down legislation. My lord, this point was actually, my lord, debated in so many words in this court, my lord. Finally, your lordship said that no, any unreasonableness will not do to strike down legislation, but manifest unreasonableness would be a ground for striking down legislation. So that's how it has developed. Now, on a case-by-case basis, my lord, we will see where that manifest line comes.
All right.
So therefore, my lord, the next thing is this, my lord, section 4.2. 4.2, my lord, in my respectful submission, for two reasons, must not be held to be a standalone provision. The first reason is, my lord, because of section 3 read with section 4.1, the statute says that nobody can extend those deadlines. Unless those deadlines are extended, RBI cannot by itself violate section 3 and section 4.1 and give somebody a right to exchange after those dates. That's number one.
According to you, he or which is not available with the central government,
Yes,
unless it exercises a notification,
yes,
cannot be inferred to have with the.
with the RBI. And Millard, that is the basis for my second argument also. If RBI has been given this blanket power, then what is the need for 4.1? 4.1 requires central government notification, both of the two limbs. 2, if it is a standalone provision, RBI can just do it. No need to provide for 4.1.
All right.
So therefore, Millard,
You have-
these are the two arguments as far as SBN is concerned. Millard, the last proposition of mine was, Millard, that a futile writ, if the matter does not,
That, the learned attorney has given a long list of.
long list of cases, Millard, I'll just add one to it, if I may,
US cases as well as Indian cases.
where your lordship, Millard,
The court should not examine academic questions.
yes. And Millard, your lordship, Millard, said this, has considered it in some detail also. Considered in some detail, have you given the copy? In Millard, 2011, and I'm just citing this for a particular reason, Millard, 2011 5 SCC, 464, it's Bholanath Mukherjee versus Ramakrishna Vivekananda Centenary College.
Coming from Bengal.
Yes, it came from Bengal, Millard. Your lordship knows, Millard, that the Ramakrishna Mission, Millard, runs schools and colleges. So, Millard, the certain amount of service law matters, Millard, emerged from, Millard, these Ramakrishna Mission institutions. And they used to be, at one time, Millard, a big conflict because, Millard, the teachers were politically aligned with, Millard, the government of the day. And therefore, Millard, they did not appreciate, Millard, the fact that the senior members of the faculty were monks. They were from the order. So this has led to a lot of litigation, Millard. The most important one is, Millard, Siddheshwari Brahmachari, where it was held that they can have a special constitution not because of Article 25, because they are not a separate religion. It was argued, Millard, and succeeded in the High Court that Ramakrishnaism is a separate religion. Not Hinduism, it's Ramakrishnaism. But that didn't succeed in the Supreme Court. But they agreed that you can treat it as a sect. Under 26, you can treat it as a sect. That it is a denomination. It's a religious denomination. So the protection was in fact given. Now in this matter, my lord, there is a service matter. And in this, your lordship will find, my lord, this proposition has been discussed. Because here, my lord, the person had some defect in his appointment, but by the time the matter came up for final, my lord, final discussion, final, my lord, decision, at that time, my lord, that problem had gone, etc., etc. So, para 42, there is another reason why no relief at present could perhaps be granted to the appellant. Though the proceedings, you know, the facts are not important. The ground on which respondent 3 was not qualified as he did not possess the necessary experience would also be no longer available to the appellants. So therefore, my lord, what happens in the end is they say that we cannot go into the question of legality of it at all. We won't go into it, my lord, because if relief cannot be granted, but if your lordships were to go into declaratory judgment on facts, my lord, it will, my lord, create difficulties in future in this very matter. If there is a declaration, for instance, by this court that that there is something wrong with this process, but no relief is to be given, then, my lord, we yes, true, my lord, but there are some cases where declaratory relief can be given.
All right.
But you won't, my lord, go into the question because, for the
I
reason.
think that's a constitution bench. right?
Yes, it is a constitution.
9 judges or 9 judges.
So if no relief can be given, my lord.
Anyway, doesn't matter.
All right, very well, Lord. I do. But those are my submissions, my lord. I will, everything I've said, my lord, will be in a note before your lordship by Friday. If that's all.
Yes, yes, we will permit. Yes. Now who will argue? Yes, attorney.
Yeah, the attorney.
Yes, Mr. Sharma, we will hear you now. After attorney, you are going to address us, right?
Thank you, Your Lordship. I oblige giving me a chance for addressing this.
Yes, we
honorable-
will give you, now Attorney General will make his submission. Thereafter, it is your turn.
Oblige, Your Lordship. I will wait further.
All right, please wait.
And sir, I will not take much of that. Yes. Because, we are addressing very important questions and a lot of questions do come and some may have an answer, some may have proposals, some have only deliberations. And two important things which came to mind yesterday. One is on the section 26 recommendation, how to really look at it. I thought I'll try to address the court on that, giving a small note. Before I do that, the other note which I read yesterday on the series of notes, the third and the fourth page, I just missed bringing to your lordship's attention. We are talking about a grace period and also talking about a window period. A grace period is an addition to the window period. If these periods are opportunities for retrieving your property was not made available, that would have been a serious issue. So if the court were to test the validity of the window period or the grace period, then the court must have a certain norm or a standard by which it can test them. By submission, the court may not devise a norm on the premise because we have a wide range of hardships which are being presented to the court, and many of them can be comprehended on certain facts, many of them cannot be. Therefore, court in a way indirectly is being called upon on the premise of hardships, which nobody is disputing. That's a different issue altogether. Devise a norm, and therefore on the devising of our norm, we will say we will push the cutoff date here or there. It's like playing a chess game, depending upon what the other party would like to move. Therefore, that I say would probably the court would not enter into. It would essentially altering the fundamental character or the nature of the law itself. Therefore, then again the court will be called upon to look into the imponderables which will arise. Because why we need to look at this? Because today when you talk of economic policy, courts will not enter into it. That's one spectrum of thought process. But we are not really looking at the economic policy against in isolation. These are all terms which are used in both in art and law for the purpose of conveying certain ideas. But we are looking at social choice theory, namely how would governments make important social policies and social choices. You will avoid something like a trade-off between vested interests and effacing of those vested interests. Therefore, governments have very often difficult issues in, framing what called a social choice policy, either in the welfare realm or in economics connected to welfare. So economics is so intricately connected to a wide range of social policy issues. So we are looking at this not merely in economic policy in that narrow sense of the term, but a wider social policy. A social policy where the three evils ought to be addressed, and a social policy where the government wants to move forward and a wide range of social welfare, social policy, economic policy, and all that put together, woven together in a broad range of a forward movement approach to certain issues. Therefore, in that process, we have all those, when you moved from a controlled economy to market economy. So we had all those issues which confronted at that point of time. We believed so strongly that controlled economy, socialism, part of preamble, we can never move into it. Balco is an example. So privatization. So when you move into one framework to another framework, and we keep on moving, the nation keeps on moving into those frameworks. Therefore, this trade-off sometimes will have to be balanced. So in that, several difficulties will be presented to the court, even to a policy maker. So how much can I stretch it? To what extent can I stretch it? So if that question was asked in favor of, give me an answer in favor of each one of those who are present before the court, then the stretching is not a policy decision making. It becomes an examination of each individual case, and then virtually nullifying the policy itself. So the essence of the policy will be so weakened. The moment the court has to enter into each and every case and says, well, of course, with some deserving cases, but then like a band which happens, or an electrical errant train suddenly halts because the electricity goes off. New York City went off for 2 days of electricity. These are issues which probably nobody can say, I will draw a mathematical equation with precision and says those who fall within this, well, I'll say acceptable to law, but not otherwise. Therefore, we have these problems there. So I would only appeal to the court to look at from the broader perspective. When you keep on saying economic policy, don't touch it, it is again from a larger angle. So in 1930s, the New York Ice Company case before the US Supreme Court, they were looking at this problem. How do you regulate trade? How do you regulate trade from a balancing perspective? And only read two you lost these two citations. One is McLean versus Arkansas, that is 211 US. I'll give a copy of the judgment. I'll just read out two passages now. This says that the legislature, being familiar with local conditions, is primarily the judge of the necessity of such enactment. The mere fact that a court may differ with the legislature in its views of public policy, or that judges may hold views inconsistent with the propriety of the legislation in question, offers no ground for judicial interference. Then a very further important statement made in Chicago versus Burlington in 219 US 549. Whether the Supreme Court also said so in so many cases. Whether the enactment is wise or unwise, whether it is based on sound economic theory, whether it is the best means to achieve the desired result, whether, in short, the legislative discretion within its prescribed limits should be exercised in a particular manner, or matters for the judgment of the legislature, and the earnest conflict of serious opinion. That's what is being presented here. Earnest conflict of serious opinion does not suffice to bring them within the range of judicial cognizance. So that will be the broad parameter. This judgment was somewhere in 1945. Now we look at the march of social development taking place today across the globe. Therefore, if every act of a legislature or an executive on the premise of a wisdom or a lack of wisdom, on the premise of a certain policy spectrum where you would have forgotten to look at. So it is easy to say relevant considerations, irrelevant considerations, etc. So when you're talking about policy perspective like this, there are several considerations to weigh rather than the narrow spectrum of relevant and irrelevant consideration. That's what I want to point out. Therefore, kindly only look at these 2 pages of my note on series where our concerns are expressed. May have your lordship to just look at it and may read it. This is a note which I gave on the series explanation. That's the 3rd page. Opening of a window for exchange and deposit of SBN's impact. In case, Lord, have that page, that's 3rd page. In case limited window is open for exchange and deposit of SBN, the following issues may arise. 1. Genuineness of money cannot be ascertained, and processing of such requests would necessarily have to be based on certain declaration being made by the party whose veracity cannot be verified. This would also provide a loophole for non-genuine holders to channelize their unaccounted money to the window. Incidentally, law enforcement agents are still recovering significant amount of specified banknotes from individuals. So the process is ongoing. Therefore, you want to put a halt and say we'll now move the cutoff date and provide for a grace period further than what's been provided for. I probably would appeal to the court. That would probably invite a lot of issues which neither the government or even the court may not be able to handle later. In the next page, we have given the total value of specified banknotes in circulation 811, and then later balance of so-and-so been given. The next bullet point, under the grace period scheme of RBI under section 411 for specified banknotes, ordinance so-and-so, 77,748 applications amount of so-and-so were received from resident and non-resident Indians by the 5 designated regional offices. Then number 2, out of this total 57,000 so-and-so were paid amount so-and-so crores, and then 20,000 cases rejected due to various reasons. So suppose, imagine lawsuit to open up the chest now. I don't know how many million cases will come on, parodying as genuine cases. So I would probably appeal to the court that issue may not be dealt with at all. Now the second, I want to just lecture on the 2621, how we are to have this small note. Please, please. And you're also asking about manifest arbitrariness. In 1935, when the US Supreme Court was dealing with the first this demonetization issues, the gold clause in the contracts were sought to be challenged. The court said if it is arbitrary and capricious, we look into it. One keeps wondering what is capricious. So we have to give either dictionary meaning or try to give an added meaning to it. That for manifest, palpably arbitrary, so on and so things kept were added on later. Right. May just need if you're not concerned. There are several provisions in the Reserve Bank of India Act 1934, other than section 26(2), which use the word recommendation as set out in the appendix. Having regard to the occurrence of the word recommendation in several provisions, and that the said word may have both common and distinct meaning, depending on the context in which the word occurs, it is desirable that the word recommendation occurring in section 26(2) is accorded the relevant meaning, which will effectuate the purpose of the section. The core meaning of recommendation is advice as to a course of action, that is, an action which is advisory in nature. It also means endorse, suggest, propose, and prescribe. The context in which the word recommendation occurs will therefore be relevant for the choice of the meaning to be ascribed to it. The subject of issuance of banknotes, denomination of such notes, and the legal tender character of such notes all form part of the composite scheme of sections 22, 24, and 26 of the RBI Act. However, the role that is assigned to the Central Board of RBI towards making recommendations in each one of these sections will throw light on the meaning to be given. Under section 22(1), the Central Board of RBI is called upon to recommend the period during which currency notes will be issued. The period shall be fixed by the central government on the recommendation of the Central Board. This recommendation is in the nature of a very limited recommendation without being related to any larger monetary other public policy dimensions. When you go to section 24(1), the recommendation of the Central Board of RBI is in regard to the denominational values of banknotes to be issued. Under section 24(2), the Central Board is called upon to recommend on the subject of non-issue or discontinuance of issue of banknotes of certain denominational values. In both circumstances, the central government will specify the course of action. It is evident that the RBI and the central government act on the exchange of relevant information. An element of interaction and consultation, howsoever minimal, between the RBI and central government will necessarily enter the processes under sections 22 and 24. When you come to section 26(2), the concept of recommendation will receive that meaning which will provide for, facilitate, and enable mutual consultation between the central government and the RBI. The very nature of the important decisions to be taken regarding cessation of legal tender will inform the processes to be built into the working of section 26(2). At a procedural level, after such a consultation has been done, for the purpose of conformity with the procedure laid out in section 26(2), a proposal crystallized in the form of recommendation that will be suitable for further action in the opinion of RBI will precede the notification to be published by the central government. That will be the correct meaning to be given. In the above understanding of the scheme of section 26(2), recommendation does not necessarily mean initiation of the very subject of cessation of legal tender by the Central Board of RBI. Since the consultative process must be said to be intrinsic to the scheme and object of section 26(2), if it is suggested that everything must necessarily emanate from the RBI, it would amount to robbing the soul of section 26(2). This would also eliminate the policy-making role. This would also eliminate the policy-making role of the central government, thereby reducing its importance in policy-making and converting it into a mere notification issuing authority. This interpretation will be consistent with the mutually reinforcing authority and roles of RBI and the central government. Important and sensitive information collected or gathered by law enforcement agencies or other authorities of the central government relating to black money and terror financing will always be necessary inputs for the RBI to discharge its role under section 26(2). Such information will be shared by the central government and wherever necessary, evaluation thereof by the central government will be important dimension for the decision-making process, particularly regarding the denominations and series of banknotes that can be picked up for declaration and cessation of legal tender. Thus read, Section 26(2) will fit into the scheme of an effective mechanism for dealing with challenges confronting the nation, namely vis-a-vis currency management and monetary policy. The suggestion that there is a reversal of roles between RBI and the central government is thus based on a narrow and pedantic view of Section 26(2). It is submitted that no reversal of roles has taken place on the above understanding of Section 26(2), and even otherwise, the necessary flow of information between RBI and the central government has taken place. Next page, you put all those sections. I don't propose to go into that. I'll only hand over a small note on the role of RBI's Central Board of Directors in the currency management. Section 7(2) the RBI Act provides that subject to any such direction, the General Superintendent, the direction of the affairs of the business of the bank shall be entrusted to a Central Board of Directors, which may exercise all powers and do all acts and things which may be exercised or done by the bank. Further, Section 7(3) adds that save as otherwise provided in regulations made by the Central Board, the Governor and in absence the Deputy Governor nominated by him in his behalf shall also have powers of General Superintendent in direction of the affairs of the business of the bank and may exercise all powers and do all acts and things which may be exercised or done by the bank. Currency management encompasses demand estimation and planning for printing, supply of currency notes, security features, distribution across a wide geographical spread, providing facilities for exchange of soiled notes, monitoring of counterfeit notes, and reporting to law enforcement agencies and undertaking eventual destruction of soiled notes. All these activities require a well-entrenched understanding of the functioning of currency, exposure to international practices, alignment with technological development in the field, etc. As with any other discipline, the RBI staff working in currency management area acquire expertise on the subject over a period of time, and various strategies are adopted in the policy-making process that includes significant technical, analytical, institutional, and dynamic input. We're looking at RBI as an institution. Policy making is also subjected to elaborate deliberation and internal examination before being put up to the top level executives and board. It can thus be concluded that decision making in RBI is a well organized and systematic process which is founded on internal discussions, elaborate research of its staff members, and expert judgment, including the top management. The board of directors were otherwise extremely experienced with expertise in their own professions, but always presented with well-recorded research proposals covering related aspects. This facilitates smooth decision-making by the board. It is not practical or necessary for each member of the board to be an expert in every aspect of RBI's functioning, which is wide-ranging. So that is how, when you have an institutional input, the board acts on the basis of the institutional input, and whatever resolution it passes is on the basis of the institutional input, and the way the resolution that is conveyed to the central government, the recommendation is emanated, and the central government issues the notification. That's how it ends.
Yes. Yes, Mr. Sharma, ML Sharma, you should start at 2 o'clock, right? But how many minutes you will take? How many minutes?
Your Lordship will give me a time to disclose each and everything. I will say whatever has not been told till now.
All right, you can start at 2, but don't take long time, right?
No, I will not take a long time, Your Lordship.
All right, come at 2.
Yesterday, I referred to that speech by the Parliament speech on 2005. I got a complete text. I'll place it for that.
I think thereafter, after Sharma completes, I think others, I think you wanted to say something, you can continue.
Global organization.
But don't take long, 5 minutes, finish in 5 minutes.
Sir, have directed me to argue after the.
Yeah, you also take 5 minutes in the afternoon, right? 5 minutes, 5 minutes each. Thereafterwards, Mr. Chidambaram will conclude. Shyam Diwan, you wanted to say something? All right, you can, both of you can conclude thereafter. I think we will close by 4 o'clock under,
I'll require 10 minutes at least.
Huh?
10 minutes.
you take 8 minutes, right? Mediation, some kind of a mediation. All right. Mr. Sharma,
Yes, Your Lordship.
be
Your
brief.
Lordship. Yes, I am coming within the brief only, Your Lordship. Because I know
Yes.
Your Lordship have already harassed since last 5 days, continue the hearing this all the thing.
Yes.
Your Lordship, outcome of impugned notification dated 8/11/2016 are death of thousands of people, destruction of economy, starvation of million people, cost of rupees 33,000 crore upon consolidated fund of India belong
This
to
is all
RBI.
argued by Mr. Chidambaram.
No. Mr. Chidambaram never told that 33,000 crore has been bared by the government of India in demonetizations till now. And serious international disputes with various countries for the exchange of Indian note lying still in the bank and people in hand in those countries like Nepal and others, Your Lordship. Now, within this, Your Lordship, I want to further say RBI 26(2), every discussion is within RBI Act, Your Lordship. I have to say RBI section 26(2) have no power except recommending to the Union of India. That's all. It's 26(2). Read together, Your Lordship. Permit me to read, Your Lordship. Just a minute. Please have it. On recommendation of the Central Board of the Central Government may, by notification, the official gazette declare that with effect from such date, age may be specified in the notification. Any series of banknote of any denomination shall cease to be legal tender. RBI have role only to recommend. Suppose, Your Lordship, RBI does not recommend, whether the government of India power, Lok Sabha doesn't have power to cancel the note also, because it is within the union list number 36. So the discussion about
No.
whether
What
RBI
is
has
that,
power or
what is
not,
that
I
you
don't
want to
come into that.
convey? You are appearing for the government of India or for the petitioner?
Your Lordship, I am a PIL. I am not favoring
Are you
government of
supporting
India.
the government or the petitioner?
I am supporting the law, Your Lordship. Let me come to the point,
All right, all
legal
right,
point
all
only,
right.
Your Lordship, please.
They have all argued on these questions. Don't repeat all these things. If there is something new, you argue.
I do
hope
not want. I want
Sharma,
to say something.
please
I'm
listen to
sorry.
us. Hope you are not in our court when it was argued. Hope you have been watching these proceedings.
You say I
For
was
5
watching
days.
the proceeding.
Very good. Then
I want to extend my argument. The word in 26.
don't repeat all these things.
No, I'm not repeating yours. I have to reach to up to my point. I have to say this, Your Lordship.
All right.
So
What
now-
is your point? Tell us what is your point.
Yeah, I'm coming, Your Lordship. Now within section 26(2), the word is given there is central government. Central government, according to General Clause Act, is the President of India. It is not the ministry, it is not the Prime Minister, it is not anyone. So the notification is to be decided by the President of India, the subject issue, not by the Cabinet Ministry. Here what happened, Your Lordship, on 8th November or on 8th November, the PM came into the TV and declared their demonetization. Till that, there was no notification, Your Lordship. Ministry of Finance issued notification without saying that in the name of the President of India it is issued. So I said the notification was not issued by the President of India, number one. Number two, 33,000 crore has been spent for this. There is a Article 110 which say if there is any expenditure from the Consolidated Fund of India, Article 110 is to be complied with. Otherwise, rules and the law is illegal and unconstitutional, Your Lordship. Now, Your Lordship, within this effect, I have to say, Your Lordship, something. I have to come date by Your Lordship. One third thing, Your Lordship. Sorry, Your Lordship, I'm little bit upset. The object what has been stated
Upset
over
with,
here by
upset with who? With us or what is? Why are you upset?
No, Your Lordship, I am little bit nervous.
If you are in
I'm
the
sorry,
court,
Your
if somebody interrupts, you can be upset. You are in an air-conditioned room, I suppose.
No, Your Lordship, I am not so rich. I am not so rich, Your Lordship. So, Your Lordship, what I want to submit here, Your Lordship, the object what has been told that it is for the black money and others. It is utter lie, Your Lordship, because the fact on 1st June 2016 to 13th November September 2016, government have already brought income tax declaration scheme of 2016, Your Lordship.
Hmm.
All the black money have already been adjusted in that. This came, the object was not defined still before this honorable court, that this is only political object purposes only. Because once black money has already been adjusted by paying 40%, why the people will hold the black money with their hand? So, Your Lordship, now this is a notification as well as the bill, I mean the act, both are being hit by Article 110 plus Article 77(1) and Article 78. You see, please just have, I have requested one ruling, that's the Shamsher Singh.
Hmm.
You see, please have the Shamsher Singh ruling.
Which is that? Give us the citation.
Yeah, I have already asked the library to send over here.
Where is it?
1974 to SCC, 83 page.
The book here?
Let's say have it, please. ये खास सूत्र है, पानी रखें यहाँ पे please.
1974. And what is the proposal?
1974, Your Lordship. 2 SCC, 831, in which you also have page 30, para 36.
Now, case law will be given, only judgments will come in. Someone from the family. Apart from that, I also read on my own.
Your Lordship, have para 26. Para 26, Your Lordship. It is at page 840. It starts 839, page 839, and goes up to 840. 839, last para, Your Lordship. May I read, Your Lordship, please? Your Lordship got it? Page 839, para 26.
Yes, para 26.
There are two significant features in regard to the executive action taken in the name of the president or in the name of the governor. Neither the president nor the governor may sue or be sued for any executive action of the state. First, Article 300 states that the government of India may sue or be sued in the name of the union, and the governor may sue to be sued in the name of the state. Second, Article 361 states that proceeding may be brought against the government of India and the government of a state, but not against the president or the governor. Article 361 indicates that neither the president nor the governor can be sued for executive action of the government. The reason is that neither the president nor the government exercise executive function individually or personally. Executive action taken in the name of the president in the action of the union, and executive action taken in the name of the governor is the executive action of the state. So let's say last three lines, we have to read it. I have to read it in the different way now. Executive action taken in the name of the president is the action of the union. That means executive action, if not taken in the name of the president, is not the action by the Union of India.
All right.
And this, and further, Your Lordship, para 25 also, Your Lordship. The executive power of the government, para 25 years, 2, 3, 4, 5, 6, 7. It is the seventh line, or last 4 line, you will say, last 4 line. In the name of the president, so any action taken in the exercise of the executive power of the union vested in the president under Article 53(1) is taken by the government of India in the name of the president, as will appear in Article 77(1). Similarly, any action taken in the exercise of the executive power of the state vested in the governor under Article 154(1) is taken by the government of a state in the name of the governor, as will appear in Article 166(1). So Article 77(1) has the one word very important, that is known as a shall. Where is it? Just have the constitution, Your Lordship, Article 77(1). Article 77(1), Your Lordship. All, may I read, Your Lordship?
Yes.
All executive action of the government of India shall be expressed to be taken in the name of the president. And again, Your Lordship, if come Article 78, it's a duty of Prime Minister as respect the furnishing the information to the president. It shall be the duty of the Prime Minister to communicate to the President all decision of the Council of Ministers, to furnish such information relating to the administration of the affairs of the Union and proposal for legislation. If the President so required, to submit for consideration of the Council of Ministers any matter on which a decision has been taken by a minister, but which has not been considered by the Council. 77 and 78, to express one thing very clear, Your Lordship. Either the Prime Minister or Cabinet, 78 says, have to inform to the President what they want to do, what they have to do, what notification they want to issue. And within Article 77, executive action is to be issued in the name of the President of India only. Now, you see, we come under Article 110. You say, please have Article 110.
Yes.
110, yes, Your Lordship. Definition of money bill, Your Lordship. When 33,000 crore has been spent upon demonetization, either it is notification or is it a bill, it comes within the money bill. And if the formality within given year not complied, it is unconstitutional. What is that, Your Lordship? For the purpose of the chapter, bill shall be deemed to be money bill if it contains only provisions dealing with all or any of the following matters, namely, Your Lordship say, the imposition, abolition, tax, alteration or regulation of any tax, the regulation of borrowing money, third, the custody of consolidation fund or the continuation of the India, the payment of money into or withdrawal of money from any such fund, payment of the money. So this 33,000 payment of the money also, the appropriation of money out of the consolidated fund of India, the declaring of any expenditures to be expenditure charged on the consolidated fund of India, or the increasing or the amount of any such expenditures. So you will see, if expenditures is done upon this demonetization act and their process, their action and their scheme, it comes within Article 110, and without complying 110, if notification or bill has been introduced in the parliament and passed and converted into the act, it is unconstitutional, Your Lordship. Next, Your Lordship. Your Lordship, there is another ruling I want to submit, Your Lordship. 1971 SCR 46 page, Your Lordship. Ruling. Ruling. Yes, Your Lordship got it.
Just 1 second. Huh?
Yes, Your Lordship.
We have.
Yeah, you also have to para 7, page 67 of this ruling, Your Lordship. UN Rao versus Indira Gandhi.
Oh, all right, tell us, it is here.
It
Which-
will be
which
noticed
paragraph?
that
Which paragraph? Read that paragraph.
para 7, Your Lordship. It will
Just
be
one
noticed
second.
that
Para 7, page 67.
From where?
may I read, Your Lordship?
Yes, tell us.
It will be noticed that Article 74(1) is mandatory in form. We are unable to agree with the appellant that in the context the word shall should be read as may. Article 52 is mandatory. In other words, there shall be a President of India. So is Article 74(1). The Constitution. So you are saying why I am reading this para? This 3 line first is important, in which it is say the word shall. The word shall is a mandatory. Cannot be read as a may or it cannot be read as any otherwise. Once the word shall is mandatory, then I have to see again Article 77(1).
Hmm.
What Article 77(1) say, Your Lordship?
Hmm.
It all executive action of the government of India shall be.
Hmm.
The word is shall. If shall is there, it is mandatory. If not,
All right, we have
compliant, then no
understood.
action is
Please
more.
proceed. We have understood. Please proceed now. Any other point? Sharma, any other point?
Yes, Your Lordship. Please, Your
What is the
Lordship.
other point? Come to the other point.
Your Lordship, the one point is important which is not discussed yet.
Hmm.
I'm sorry. Exchange allowed. Yes. You will say they demonetize good enough. They gave the time to exchange the note good enough.
Hmm.
They did not arrange the note, that is also good enough. But you will say there must be some principle behind this law making that you cannot exchange this note after 30th December. Why? There must be some principle, some logic. They know they are not having the sufficient note to exchange, but they did it, and thousands of why I filed this people not for the money
This
or
point is already argued, Sharma. This point was already argued. This was argued. Go to the other point. Next point. This was already argued. Go
So
to the
your-
next point. What is the next point?
net my one point and prayer also, Your Worship, the how we will compensate to that 1,000 people who were died during this exchange process.
Hmm.
I have a list of more than 90 people or in all over India who were died standing in the queue in the house also, and other than I do not know about the thousands of people those who are died due to starvation because their money have gone. They have no money for food, nothing at all for that one. So, Your Worship, within my 3 proposition, Your
All
Worship,
right, sir.
a last point I left, one last point I left, that is the serious have not been taken yet now by anybody. On 8 November, Honorable Prime Minister declared the 500,000 note is now no more legal tender. But Your Worship, just before 8 p.m., around 7:30, BJP have deposited 1 crore rupee in a Calcutta bank, Your Worship. Why any action has not been taken till now in that? And not only that, immediately within that day, 1,000 crore rupees were deposited in the Gujarat also. I do not have that one. But the Calcutta incident I annexed over here, NHF P2, Your Lordship. If law is equally upon all, it should be upon those people also who deposited this note and having the internal information, how this information leaked. There is the argument that it should be secret, it should not be leaked. That's why we did all that one. Now, how this information was leaked to the BJP people who deposited this 1 crore in
All
Calcutta?
right. We have understood. We will consider. All right, sir. All right.
Oblige, Your
Now
Honor.
we will argue. Uh-huh.
What Mr. Sharma had said, my petition is based on the leakage. It's a Dainik Jagran news item which has been published on 27th of October. There are few people who are in the friends in the higher in the government
All.
One more submission. Your Lordship, my learned senior colleague appearing for RBI made a statement that no one was denied an opportunity to make deposits into the cash, into their bank account. I am standing before your Lordship for that reason only. My banker refused to accept the cash deposit into my KYC compliant account within the specified period. And they have issued an email to that effect that we cannot accept any further cash deposits from you. So that is the falsity in the claim.
What is the date?
21st of December 2016.
Then you should have gone to some other bank. This is what Mr. Gupta said.
Your Lordship, the other banks were not opening bank accounts at that point in time.
All right, we have understood. Next case, let's move on to argue.
May just submit, I appear for the banking question. Your Lordship, the account in question has been reported for serious fraud and he refused to update KYC details. That is why he was refused. In fact, Your Lordship, he deposited 1.2 crores, the fact he has concealed, converted it and then as a conduit was collecting cash and bringing it and therefore we refused.
All right, over. Now we will consider. Yes. Tell us.
Senior citizen, she has lived into America in April 2016, but she come back in July 2017. The RBI, but they are denied by say like 85,000.
All right, sir. All right. Next. All right. Yes. What do you want to say? All right, sir. All right.
Yes, I appear in IA number 54299 of 2018. This is by the Global Organization of People of Indian Origin Millets. They have a presence in 100 countries in the world. And along with my petition, 500 people have signed and shown how they have not been able to come to India and exchange their notes with us. So millets, there are two categories of non-resident Indians. One is the non-resident Indian who holds an Indian citizenship and has an Indian passport. He is, if he is out of the country for 6 months, any Indian citizen, he will be treated as a non-resident Indian. The second category, millet, which is recognized by Government of India, is the overseas citizen of India or person of Indian origin. Way back when Dr. L.N. Singhvi in those days decided that diaspora all over the world are an asset to this country and they bring in valuable foreign exchange and they must be recognized and they must not be harassed and they must come into the country and get equal rights. Millard, under the Citizenship Act of Section 7, a notification was issued on 8th April saying that all overseas citizenship of India card holders or PIO, first became PIO card holders, then it became overseas citizen, will be treated at par with the non-resident Indian. Now, Millards, the Government of India in its wisdom thought that 52 days is enough for anybody having, Millard, in this 500 people I have counted, somebody is having 50,000, somebody is having 20,000, somebody is having, all of these people are not going to spend 2 lakhs to visit the country to exchange their money within that given 52 days. So far as the OCI card holders and PIO card holders.
What are you suggesting? So some more time was required. No, the tickets would have reduced, is it? Flight tickets after.
No, not the point is, I was not given enough time. Those category of people did not get, including the NRIs themselves. I am not here for any publicity. I am not here to waste your lordship's time. Or repeat any argument that has been advanced.
No, insofar as NRs are concerned.
No, your lordship is here. That's all I'm saying. Give me 5 minutes of talk.
Insofar as NRIs are concerned, the period was extended up to 30th
June. Even 30th June, just my learned friend may have something else to correct. But this is what I'm aware of. And even minutes, there are people who don't visit the country. Minute, I've got entire statistics. My return submissions will show that there are more than 20 to 32 million people of Indian origin.
Suppose if somebody doesn't return for 3 years.
Millard, yes, I'll give you that example. Millard, what is the overall purpose of the notification? It is to deal with fake currency. Only fake currency, nothing else. And
there are 2 other objects.
Yes, that I know that. I am talking about fake currency. According to them, leads to terrorism and leads to drug trafficking. But I'm aware of these, but I have spent enough time.
No,
on
no,
this
no,
before the
terror-
court. I have
terror-
appeared for narcotics control.
Oh, terror funding need not be of fake currency. It can be by regular currency.
Let's,
So,
any which way, let's any which way, but it starts with that fake currency is leading to this, and there are lots of this thing, and they're unable to make out with fake currency from real currency when there are seizures, so and so and so on and so forth. And when it is changing hands, that is the overt purpose. I would say this, that if that is the case, the moment I'm not challenging demonetization. That I'm just trying to explain the situation. The moment currency is demonetized, fake currency goes out of the window. Nobody can come and exchange fake currency at a bank. That is the first step. Your fake currency is gone. Then kindly treat all those people who have enough, whether it's 1 lakh, 2 lakhs, whatever. Till 30th December, a resident Indian could exchange unlimited amount of currency. If he had 200 crores, he could go and deposit it to the bank by 30th December and deal with it under the tax laws. It does not take more than 5-10 minutes to make a preliminary point. If your lordship feels there is something, some substance, your lordship may give me extension of time, or otherwise your lordship may not do that.
preliminary, still you are in preliminary.
Yes, Millets,
thought-
very much. Kindly see this. Millets, I am going to talk about two principles: promissory estoppel and legitimate expectation, all of which is being later.
Estoppel is applicable against the statute.
Millets, the law that says is, kindly see, the law says,
Promissory estoppel is applicable against the statute.
yes, Millets, kindly see, the law says that if there is already, I have by statute through the Citizenship Act been treated equally with my NRI brothers and sisters, and therefore I must have the same rights that they have, which has been set by notification under the Citizenship Act directly. First point. Second point is, Millets, my rights already fructified where I'm entitled to be treated equally as my brothers and sisters earlier in time. Subsequent law, Millets, that is what legitimate expectation and promissory estoppel cases right from the UK and the US say, that you cannot overturn that right which is already come into Millets, and I have given the case law. If your lordship feels that I am not, I'm not saying that there is no substance, Millets, you will buy my written submissions there. But however, if your lordship gives me another 5 minutes, I will explain this to your lordship. Now, Millets, I have made a point that fake currency goes out the moment you demonetize currency. It cannot come through the banking channels. Anybody who walks in with any amount of currency to any bank account cannot exchange fake currency across the counter, or it will not get credited into his account. Millets, that's the first point. Now, if there was, Millets, I am aware, I have been on this side also, Millets, there is financial intelligence unions, there is a directory of revenue intelligence. It is impossible for anybody to deposit 100 crores and that could get credited to his account without the government of India knowing its origins, or it could have even said, all right, this currency that has been deposited will not get credited to your account. You KYC particulars, whatever you want to do, you can satisfy us that this is not come from money laundering, drug trafficking, or arms dealing, or terrorism. Millets, that was not the way it was taken. It took a different group. In any case, Millets, the other point that I'm trying to make is that promissory estoppel and legitimate expectation is there. That Millets, I will show your lordship statistics, which are here, as to what is the number of people or people of Indian origin who are living overseas. Millets, is a person who is working in Qatar or Dubai or any laborer who keeps 10,000 rupees in his pocket. Should he lose it if he doesn't come in those 52 days? Is that what the government of India was trying to do? Well, that is unfair. That is unjust. And that is what these are the people I'm trying to represent and fight for. That your fake currency is gone the moment you demonetize currency. But do not take away an honest taxpayer's money who has kept it in his pocket and is living overseas. And he is not going to buy a flight ticket of 1.5 lakhs or any in that region to come and change 20,000, 50,000, 70,000, whatever it is. Let's say 25,000 per person. So if there is a family of 4, 1 lakh rupees cash can be brought, and people keep 50,000 to 75,000 to come in the taxi, everything. It's all stated here in 100 pages of people who have kept their money in their pockets to come to India and deal with it. Does the government of India's policy mean that all these gentlemen, ladies, and all these young people who of Indian origin should lose their money if they are not able to come on time? And which Millard I ask myself this question, Millard. That is 52 days for anybody who's living in any part of the world enough to come back and exchange the currency? It is not possible. Millard says the 30th June was given to my brothers who are living with me there, but who have not taken up citizenship. But I am not able to do it merely because I'm of India. You issued overseas citizen of India card to me. The government of India did. And said you have right. Millard, may I read those?
No,
right?
it's all right. We will.
Yeah, now kindly see, if your lordship wants me to read the judgments on legitimate expectation
Not necessary.
and promissory estoppel, I'm willing to read it.
No, not necessary.
Therefore, Millard, I would urge your lordships to kindly see at least the 500 people who have signed this petition to see how they have lost their hard-earned money.
All right, sir.
That is the only point I'm
All
making.
right.
The rest is in my.
All right, sir. Thank you. Thank you. Yes. Mr. Chidambaram, who will argue?
I just want to point out the relevant.
Tell us.
So I would just point out the relevant paragraphs which will not be considered while.
No, tell us what is the, you have already made your submissions. No?
Yes, Milord, I have brought in some statistical data, which is on the US State Department report. Milord.
What is your stand, firstly?
Milord, in my writ petition, Milord, I must say that I had in the beginning
You
itself,
have prayed for quashing the notification.
Milord, I have prayed in my writ petition alternatively, Milord. I had said that I am not against the demonetization, but at page 10 of my writ petition.
No, what relief you have sought?
Said, my lord, petitioner is not against the said scheme of phasing out specified banknote, but against the manner of its implementation. Lord. In my prayer, Lord, I'm just giving mandamus appropriate writ against the respondent to provide methodical and reasonable time frame to citizens of India for exchanging the specified banknotes to legit.
So according to you, the time frame of 60 days is not sufficient.
This is not now not of not relevance. So that's why in the beginning I had said means the issue remains to be academic exercise. But not to assist my lord in relation to the aspects which have been discussed before this honorable court. Being officer of the court, Lord, I have brought in certain data on the basis of authentic report of US State Department, ITFT, and then Lord, various important which have connived to the extent that in fact demonetization has benefited the country in certain manner. So Lord, all this I have
That is already placed on record by the learned attorney.
So Lord, I would only point out the relevant paragraphs.
You want to argue against your petition now?
Milord,
All right, we have understood. Leave it. We have understood. All. Yes.
Make me do Well, I won't repeat myself. I just recall each proposition and leave it there. Only on the last three, I wish to make some submissions. So the first submission is that there are only, under the law as it stands today, there are only two methods by which the government or the RBI can demonetize currency. The first is the legislative method. The second is traced to Section 26 of the Act. Now, obviously, in the first method, the RBI does not apparently is not in law, because it's a law made by Parliament. In the second method, RBI plays an important role. I have submitted to your lordship's consideration as the first proposition that any in Section 26 must be read as some, and it will depend upon the context. According to me, the context is there is a plenary legislative power. There is nevertheless Section 26. And the third and most important context is on two occasions in the past, when they wanted to demonetize all series of a denomination, the government resorted to the legislative power. That has a bearing on the context of 26. just as lawyers submit their interpretation of section 26, just as courts will eventually interpret section 26, the government of the day on 2 occasions held that the way to demonetize all series of one denomination was a legislative method and not under section 26. That, according to me, provides an important context which your lordships will bear in mind. And therefore, your lordships may consider whether my submission that under section 26, you cannot demonetize all series of one denomination is valid or not. My lord, that any will always be contextual. Citation. Contextual is, my lord, held in 1996, volume 8, Supreme Court cases 540. Any is always contextual. Paragraph 12. That is my first submission.
Yes.
I'm done in the rejoinder on that.
Yes.
The second submission is, if your lordships are not inclined to read any in section 26 as some, and that any in section 26 will include all series of a denomination, then I submit that is a drastic power which must have some guideline. Well, the guidelines are usually found by the courts in either in the preamble or in the statement of objects and reasons or in other sections of the Act. My submission is on the second proposition is there is nothing in the preamble which will guide section 26. There is nothing in the statement of objects and reasons which will guide 26. And I do not find, nor was any section of the Act pointed out, which will throw light on the interpretation of section 26. There is no other provision of the RBI Act which throws light on section 26. Therefore, if section 26 is interpreted, as my learned friends on the other side will say, to confer an absolute power to demonetize all series of any denomination, which naturally includes all denominations, that is a drastic power, which ought not to be read in the 26. But if your lordships are inclined to read, I say this section is unconstitutional. It contains no guidelines at all. That is my second proposition, and I'm done. The third, my lord, is the most important submission, which I will take 3-4 minutes to answer and rejoinder to what my learning friends. Firstly, it is common ground now that all matters relating to currency is vested in the Reserve Bank of India. In fact, my Lord Justice Ramasubramanian's judgment in Internet categorically says all matters relating to currency are in the RBI. In fact, my learned friends did not dispute the point. If all matters relating to currency, currency management, issue of currency, etc., is to be vested in the RBI, can the executive government advise the RBI to make a recommendation? That's the critical issue here. The affidavit clearly says, government advised the RBI to make a recommendation. Kindly see, my lord, in the RBI Act, they take over. Just look at the preamble. The first paragraph. And generally operate the currency and credit system of the country. And this was added as a monetary policy framework. And as far as currency is concerned,
Section 3.
just kindly look at '22. The bank shall have the sole right to issue banknotes in India and may for a period which shall be fixed by the central government issue currency notes of the government of India supplied to it by the central government, and the provisions of this act applicable to banknotes shall apply to all currency notes of the government of India issued by the central government or by the bank in like manner, as if such currency notes were banknotes, and reference in this act to banknotes shall be construed accordingly. On and from the date on which this chapter comes into force, the central government shall not issue any currency notes. But earlier, the only 1 rupee note was issued by the government of India. It was signed by the Secretary, Department of Economic Affairs. All other notes are signed by the governor.
28A. 28A.
Yes. Now, my lord, by virtue of 22, when this chapter came into force, RBI may issue the currency notes supplied by the government of India, and then on and that from date, the government shall not issue any currency notes. And I'm obliged to my lord, look at 28A. Issue of special bank notes and special 1 rupee notes in certain cases. I'm not reading the whole section. Therefore, central government has no power to issue currency notes. And anyway, 1 rupee notes are not being issued. Now I found even 20 rupees a coin now. I saw a 20 rupee coin. Therefore,
Only person who issued.
yes,
Mr. Venkatramanan,
yes,
he had the occasion to sign all currency notes as RBI governor.
yes,
And then he signed 1 rupee note as finance secretary.
yes, because he was for a time being appointed to be in charge after the previous governor.
Venkatramanan.
After the previous government, I think it was
A very long time back.
Malhotra, I think. His term was terminated,
Yes.
and then Mr. Venkatramanan took over as governor, and he remained there for 2 years. Therefore, my lord,
Venkatramanan.
therefore, and then this is now sanctified by the judgment. Currency is a matter only for the government or only for the RBI. If that is so, please read 26(2) in that light. 26(2), my lord, is preceded by 24. 24 also says bank notes of the denominational value of 2 rupees. 1 rupee is deliberately left out because that is the government issuing it. And then the central government may, on the recommendation of the central board, direct the non-issue or the discontinuance of issue of bank notes of such denominational value as it may specify in this behalf. Either say we will not issue it, or say we will no longer issue it. Discontinuance is no longer issue. Non-issue is we will not issue. But both decisions have to be taken by the central government on the recommendation of the central board. Whereas, see the language of 26(2), it does not say central government may, on the recommendation of the central board, by notification. On the contrary, it says on the recommendation of the central board, the central government. The same act, 24(2), uses the word central government may, on the recommendation of the central board. 26(2) says on the recommendation of the central board, the central government may by notification. Well, it may be a distinction without a difference. I leave it there. But all I'm pointing out is, given the fact that the exclusive power to issue currency notes is only with the Reserve Bank of India, my submission on the third proposition was, it is only if the central board recommends the central government can act in the matter. The process cannot be reversed by the central government advising the RBI, and the RBI, and I submit this without any disrespect, meekly submitted to the advice and submitted its recommendation after a 1 hour deliberation on one day. Now, whether the affidavits are very clear, the affidavit of the RBI and affidavit of the affidavit of the central government filed where is the page? The affidavit of the central government filed on what date? October 18 at page 39. Well, it's not, these words have been loosely used. These words have been used apparently on competent legal advice. These words are important. First volume, October 2018, counter affidavit on behalf of the Union of India, at page in 906. Volume 1. I have numbered it as volume 1.
Para 29.
Para 31 and 32. Actually. At running page 39, which is stamped on the top. What Justice Nazir's copy is missing.
Yes, yes.
All right, please proceed. I will
Yes.
still share. All right.
I'll read only para 32.
Huh.
The government of India, therefore, just read the first paragraph, earlier paragraph. The government of India and the Reserve Bank.
Paragraph 29 onwards, that has been all been read to us. We are marking as para 29, 30, 31 and 32.
I'm not reading all of it again. I'm just emphasizing the word. The government of India, therefore, on 7/11/2016, advised the Reserve Bank that to mitigate the triple problems of so and so, Central Board of the Reserve Bank may consider withdrawal of the legal tender status of the notes in high denomination. It was advised in that letter that cash has been a facilitator of black money, elimination of black money. They also observed that in the last 5 years, there has been an increase in the circulation. There have been widespread report, etc., etc. Therefore, Miller, it emanated from the government is beyond doubt.
I think returning as explained your style is written this way.
Now, RBI.
Your main emphasis is that the procedure should have emanated from the RBI.
Yes.
And merely because they advised the RBI, the procedure has not been in accordance with section 22.
That's my submission. I'm saying both affidavits affirm
Yes, yes.
the position that I.
There is no dispute on that.
Both
On the contrary, their stand is that
Now an attempt is being made. We were in discussion for 6 months. We exchanged, all that.
that is what this affidavit also says from para 29 onwards.
Yes. RBI's affidavit.
No, this affidavit of the central
This
government,
affidavit says.
It is
Yes.
the affidavit.
Yes,
para 29 onwards.
yes. Para 29 is about introduction of new series of banknotes.
No, what they are emphasizing is that there has been a continuous discussion between the Union of India and the RBI
I'm sorry,
on
madam.
this issue.
That's not what they say. In the last few years, RBI and the government of
The
India.
argument of the
have been working.
learned attorney appears to be that the demonetization cannot be taken into consideration in isolation. It's a part of the general economic policy, which
I'll come to the economic policy and monetary policy. All I'm saying is paragraph 29 to paragraph 31 is only about introduction of new series of notes. The introduction of new series, as the learned AG said, new security features, new design, color, new photograph, etc. Then 29 to 31. 29 to 31, please read it carefully. It's only about introduction of new series of notes. And then in paragraph 30, it says, the Reserve Bank also embarked since January 2014 on a program to withdraw all the notes issued before 2005. Withdrawal of old series notes periodically is a standard international practice followed by the note issuing authorities. Therefore, there are two separate things. Let's withdraw the old series and let's issue new series. We have no quarrel with that. As far as demonetization is concerned, with the note will be no longer legal tender. The first paragraph is paragraph 32, and it makes it abundantly clear. Government of India advised the Reserve Bank, government advised in that letter, etc., etc. Now, what does the RBI say? We were sure. RBI's affidavit, first affidavit. Paragraph 4, which I read, my lord, at page 42.
two affidavits.
What is that?
I'm only talking the first affidavit.
It is 15th of November 2022.
Yes. The second affidavit is,
No, that is 22.
There is a compilation of affidavits. So
yes,
they have given compilation of all the affidavits.
this is Mr. Howard Cole.
That is second affidavit. Hawak-Ullah.
It's the second affidavit. Very well, Madam. Your Lordship may have this affidavit. Paragraph 4. It starts with the Deputy Governor's memorandum recommending withdrawal of legal tender, along with a copy of the letter dated 7th November, received from Ministry of Finance, and draft scheme for implementing the withdrawal of legal tender was considered the board on 8/11/2016 at 5:30 p.m. So the recommendation, which was received on 7/11, along with the Deputy Governor's internal note, was considered on 8/11. And then the next two paragraphs are important. The board discussed various relevant aspects. So the board was assured that the matter has been discussed between the central government and the Reserve Bank of India and had been under discussions over the last 6 months. The proposed steps presents a big opportunity to take the process, etc. 3. So the board was assured that government will take mitigating measure to contain the use of cash. So the board considered the memorandum and after detailed deliberations concluded that in larger public interest, the balance of advantage would lie in withdrawal of legal tender status, etc. Now, here I pause and say that these are the two documents which they rely upon, namely a letter of the Reserve Bank of India, the Deputy Governor's note, and the discussion in the board, which must be obviously minuted. Why are they holding it back? But I have repeatedly said from day one, these documents are absolutely necessary for your lordships to decide this issue. We must know what material they had, what consideration they did. Your lordships, I started by saying, and your lordships were pleased to observe, we are not concerned with the decision. Look at the decision-making process. And the decision-making process starts with a letter from the Government of India, a Deputy Governor's note, and the minutes of the board meeting of 8/11. Obviously, there is a recommendation thereafter to the cabinet, and then there is a cabinet minute. Leave out item 4 and 5. The letter 7/11, the Deputy Governor's note of a 7/11 or 8/11, and the agenda note placed before the board and the minutes of 8/11, they should be placed before your lordship. Without those documents, I would submit with the greatest respect, your lordships cannot come to the conclusion whether the decision-making process was based on relevant material, eschewing irrelevant considerations, and whether there was, whether the board had taken into account all the consequences of their decision. Without these three documents, we cannot reach a conclusion on this issue, is my respectful submission. Look at the internet case. I'll show the paragraph. In internet case, material was placed before the court. After perusing the material, the court came to the conclusion, listen, you have not taken into account relevant considerations, and you have banned the exchanges, and we strike it. That is the only ground on which it was struck down. How do we know whether relevant considerations were considered? These affidavits are not the relevant consideration. I was arguing once a case for the University of Madras and the Madras High Court. And the usual enthusiasm, I was saying all kinds of things, saying university did this, syndicate of the university considered it, syndicate of the university. We were switching over from 11+1 to 10+2. So that switchover year, several students were affected by the examination. Justice Natarajan, who eventually came to the Supreme Court, said, is this a decision of the syndicate or the advocate? Therefore, these affidavits are prepared on advice.
Like
Let's
UN
see the documents.
This UNR Rao appeared for the university.
Yes, no, I was counsel for the university, but earlier he was counsel for the university. Just to Natarajan said, this is the syndicate's decision or the advocate's decision? Therefore, my lord, please ask, call. At this stage, I'm not even asking that it be showed to us. I've been quite restrained in my submission. Please look into it and please satisfy yourself that relevant considerations were taken into account and irrelevant considerations were eschewed. And they have considered the proportionality of their decision, the proportionality of the, or the enormity of their decision, and what consequences it will have. Without that, my lord, without that, it is the blind leading the blind. What are we talking about? The heart of my case is the decision-making process in 26(2) was deeply flawed. Answer to that is we have filed an affidavit. Number two, they are not claiming privilege within the meaning of the R.K. Garg proposition. They can only claim privilege if they file an affidavit by the Secretary of the Department. I'm going to show that paragraph. They have not claimed privilege, neither in the affidavits nor in the oral arguments. Therefore, my lord, nothing stops your lordship from asking them to produce for your lordship's perusal. I'm willing at this stage, my lord, in the rejoinder stage to say, please don't show it to me. Please look into it yourselves.
All right.
Whether the decision-making process is flawed or not cannot be decided in the absence of the material. Now, please see, my lord, R.K. Garg. R.K. Jain, I'm sorry. What did I say? R.K. Garg. 1993, I've given the book, 4 Supreme Court cases, 119.
I remembered R.K. Garg today.
I don't know why.
No, that is because he argued that bearer bonds case.
There are points.
Yeah, very famous.
Stuck to man.
Yes.
Look at paragraph 11. The Solicitor General, though brought the file on July 21, I assume, my lord, since the learned Attorney General said, there's no problem, we are not hiding anything. I am sure he has got the document. Because he can't say, I'm not hiding anything without the document. On July 21, objected to our inspecting the file and desire to claim privilege.
The reading para?
11.
Para 11,
Page 135.
page 135.
Yes.
The Solicitor General, though brought the file on July 21, objected to our inspecting the file and desire to claim privilege. The file was directed to be kept in the custody of the Registrar General till further orders. The Union was directed to file setting out the grounds on which the claim for privilege is founded. 4 lines below. Thereafter, an application was filed supported by the affidavit of the Secretary and the State Minister also filed this affidavit. I'm skipping all that, Madam. Paragraph 12, 13, all deal with the law. And then kindly come to paragraph 14 towards the end. The petitioner must make strong prima facie case in order to discovery order 95, and it must not be a hunting expedition to fish out some facts or an attempt to cause embarrassment to the respondents, nor for publicity. Then section 123 of the Evidence Act gives a right. In a democracy governed by the rule of law, the state is treated on a par with a person by Article 19(6) in commercial industrial activities. It possessed of no special privileges. This court in the state of UP held that an objection claiming immunity should be raised by an affidavit affirmed by the head of the department. The court may also require a minister to affirm an affidavit. They must state with precision the grounds or reasons in support of the public interest immunity to produce unpublished official records, state documents, should be made through an affidavit generally with the minister concerned, in his absence with the secretary. In the latter case, the court may require an affidavit, etc., etc. Then last 5 lines. If the court is satisfied from the affidavit and the reasons assigned for withholding production or disclosure, the court may pass an appropriate order in that behalf. The court, though, would give utmost consideration and deference to the view of the minister, yet it is not conclusive. The claim for immunity should never be an administrative routine, nor be a guard to avoid inconvenience, embarrassment, or adverse to its defense and action, the latter themselves a ground for disclosure. If the court still desires to produce a record for satisfying itself whether the reasons assigned in the affidavit would justify withholding disclosure, the court would, in camera, examine the record and satisfy itself whether the public interest subserves withholding production or disclosure or making the document as part of the record. Lord, I would submit the most humbly, it would certainly not advance the cause of justice if your lordships don't look at this document. This entire case is about decision-making process. We know the decision is a fait accompli now. We know that the decision cannot be reversed. But we want the law to be laid down. What is the decision-making process in 26.2? We can't read only 26.2 and come to a theoretical conclusion as long as there is a recommendation, which is according to the RBI, the penultimate step, and the final step is the notification. Suppose, Miller, this 24 hours was reduced to 24 minutes. Would your lordship still uphold it? Suppose it is 24 minutes. The RBI governor, RBI board meets, and then the governor sends it, and then the cabinet is ready, and after 24 minutes, the decision is made. Would it be still upheld under 26.2? Look at the enormity of the consequences. Can a decision of this nature be taken? Having taken the decision, why are they fighting shy of telling your lordships how the decision was taken? Your lordships have repeatedly said we can't question the wisdom of the decision, but you can certainly question the decision-making process. At least if the decision-making process has been fair, it's possible that in most decision-making processes which are fair, the decision will be fair. You can still follow a decision-making process which is fair and still come to a, Einstein said, insanity is doing the same thing over and over and again and expecting a different result. In 1946, governor said black money and fake currency cannot be abolished by demonetization. In 1978, governor said this cannot be done by this method of demonetization. In fact, he used the word unprecedented. There is no case, no example of demonetization in such circumstances. The only two circumstances are when hyperinflation and the currency has become worthless, or the very old currency, which is no longer used or usable. There is no other example of demonetization. And having taken that grave step, why are they fighting shy of this? If they are able to defend the decision as they have done over the last 2 days, why can't they defend the decision-making process by placing the documents before your lordship? They should be able to confidently defend not only the decision, but the decision-making process. But I submit, Miller, in the absence of these documents, what is this? We come to that. Now, that is my submission on the 3rd. Yes.
See that you said there could only be 2 objectives about the demonetization. In fact, we have taken out a list of countries which have experimented demonetization or as well as reasons from 1873.
Yes.
There are other
Up
reasons.
to, up to Miller, up to, if I may ask.
Up to 2016,
Okay.
from 1873. 1873 in USA, the silver was, silver was said no longer valid. Then 1923, Germany, the objective was stated to be to prevent inflation. 1969 USA, they said to resist black money.
Yes.
So,
No, what did they demonetize now? That's the question.
no, they demonetized the currency. See, that led to the, in fact, American banking system. Then 1971 UK.
Your lordship may pardon me. I was in the US at that time. What, they may have demonetized some high value currency.
That's right.
Which is very.
No, the
low
objective
in
cannot be
circulation.
limited to two is what I'm saying.
No,
Objective is not necessarily limited to two.
inflation, I said so. Hyperinflation is one ground to
No,
demonetize.
black money is also another ground. In fact, some of the countries like Ghana, etc., the Myanmar,
Look, those
They
are,
have-
those are certainly not Zimbabwe and.
just to say on the
Argentina,
academic,
Myanmar.
on the
Certainly not
academic
like-
side, to say that there could only be two
No,
objectives may not be
maybe,
strict.
to the best of my knowledge, these are the two objectives. But if there is hyperinflation, clear. In fact, most demonetizations are based on hyperinflation, where the currency goes to a million, 1 rupee becomes effectively worth less than 1,000,000 rupees can buy you a cup of tea. You have to demonetize the old currencies and issue new currencies. Post-war, Germany demonetized its currency and issued fresh currency because they didn't want the Nazi regime currency, which apparently had been
Anti-Semitic.
wholesale counterfeited, and all kinds of people were flushing in currency into the system. Both the then finance minister, chancellor, and the finance minister, Erhard, demonetized the currency and issued fresh currency. I'm not saying they can't be, maybe there was, but these are the two examples. But if they are confident of defending the decision, why can't they defend the decision-making process? Let us see what was considered, what was decided, what was recommended. Well,
See, in fact-
close my
In
submission.
fact, the learned Attorney General
Yes,
submitted that the central government cannot look at it in a very myopic way.
yes.
There are so many considerations. And therefore, it may not be only to the two reasons which you submitted. There is security of the state, the economy, to be rid of black money. There are so many terror funding. Therefore, is it not possible for the central government to initiate a proposal of demonetization?
Great response.
Why should it be only
Three objectives.
RBI?
Three objectives are actually two. There are actually two objectives. 1A, 1B, and 2. 1A was fake currency, and 1B is fake currencies financing terrorism. So it's really one objective. They put it as two. Let's take it as 2 or 1. Fake currency and fake currency financing terrorism. Number 2 was to eliminate black money. These are the two objectives. These two objectives were opined by two governors as not achievable through demonetization. That is history. They want to do it again. Fine. They can share information. They can share information. Let us see what information was shared. And what did the governor and the RBI board take into consideration? Surely, my lord, if RBI board was aware of the currency in circulation, etc., surely the RBI governor must be fully aware of the fact that in 1946 and 1978, the RBI opposed demonetization and they resorted to the plenary power of legislation. And surely the RBI, history of RBI is published by the RBI. They must be deemed to know that also. And there have been only 2 demonetization prior to this one, at least in recent history. We don't know about 1800s or so, 1946 and 1970. They must be deemed to know that. So if they recommended it. What did they recommend? I don't know, Mira. We are still in the dark. We are still looking for a black cat in a dark room. Whether the black cat exists or it doesn't exist, we don't know. So I would implore your lordships, it would be not doing justice to the petitioners who are before your lordships, unless your lordships see these documents and satisfy yourselves that the decision-making process was fair and not arbitrary, and they took into account relevant considerations and eschewed irrelevant considerations.
In my note, I.
Please wait, please wait, please wait, please wait.
That is my third proposition. Namala, there was some reference to monetary policy. But I don't want to convert this exercise into a debate on monetary policy. But the best of my knowledge, and I will support it, demonetization has nothing to do with monetary policy. I have just given a compilation. With your lordships, just look at the thin compilation. I'm not given it yet. Just see that compilation. And I have to explain the 2017 Act and then the relief. I'll be done. This one. But I'll come to 1 and 2 later. Just look at the item 3. This is, my lord, from former Governor Rangarajan's recently released book, Forks in the Road. He's by universally considered one of the topmost monetary economists in the country. Now, this is from the Forks in the Road. Now, kindly see what monetary policy is, and Justice Ramasubramaniam in his judgment also deals with this subject, and in fact points out to a chapter in the RBI Act on monetary policy. Nothing to do with demonetization. Kindly see this time. So to throw the phrase monetary policy, economic policy, I'm sure it was not to frighten the court into looking into the matter. And these words cannot stop the court from looking into the matter. And to say you're not experts. Are we experts? We're not arguing here. We are not experts either. But we gather material and place it for you.
Mr. Chidambaram.
Yes. Everyone?
Except Mr. Chidambaram.
I'm not an expert.
But the Evidence Act says court is an expert's expert.
Therefore, my lord, to frighten a court by saying this is expert, experts have looked into it. The lawyers and courts educate themselves on the subject and apply their mind. How do your lordship decide patent cases? Are you engineers? Are you chemical engineers? Are you microbiologists? Yet you decide patent cases. How do you decide trademark cases? Therefore, my lord, to say that this is experts have looked into it, you can't even ask us. I think, my lord, it's an utterly futile argument today. Cases will involve technology. The crypto exchange, the bench which heard that did a lot of homework. And I'm a little worried. I'm fine that Justice Ramasubramaniam has done homework on demonetization also. So I'm a little worried whether I'll be tripped in my argument. Therefore, to say economic policy, monetary policy, all that, my lord, is irrelevant in this day and age. Cases will become more complex. Cases will involve high technology, and you have to decide. Kindly look at this one. The stance of monetary policy in any year. Now, the broad objectives of monetary policy have remained the same over the years. They are to ensure adequate expansion in credit and to moderate monetary expansion to maintain a reasonable degree of price stability. In fact, monetary policy is only concerned with price stability. Price stability will depend upon whether more money is chasing goods or the less money is chasing goods. That's one of the factors. But this is the objective. Then next one. The objective of price stability, however, is not an end in itself. It's a means to achieving growth. Except in a very short period, there cannot really be a conflict between the objectives of price stability and growth. Even on considerations of social justice, inflation control is important as inflation hurts the poorest segments of society. The 1994-95 report explained the multiple factors influencing inflation and the role of monetary policy. I'm not reading all that. Now kindly color over the page. Kindly come to page 15, running page 15. Getting back to the objective of monetary policy and the mandate for RBI, report added, autonomy or independence of central banks is an issue that is being debated widely over. Autonomy has many dimensions, of which the most important relates to the conduct of monetary policy. History shows that successful monetary policy requires not only a high degree of operational freedom for central banks, but also a clear enunciation of the dominant objective of policy. In industrially advanced countries, inflation control has become the dominant, if not the only objective of monetary policy. With the discontinuation of automatic monetization of central government deficit, a major step towards functional autonomy has already been taken. However, there has to be a general consensus on the need to keep the inflation rate around a certain level. Let's skip all that. Kindly come to page 12, last three pages. In any monetary policy framework, a key ingredient is the enunciation of its objectives, as its actions are guided foremost by the objectives. A recurring question in this context is whether monetary policy should be concerned with all the goals of economic policy. The issue of objective is important because of the need to provide clear guidance. Indeed, this aspect will assume added significance in the context of the increasing stress on autonomy of central banks. Then kindly come to page 19. In talking of the objectives of monetary policy in India, I had said on an earlier occasion, in a broad sense, the objectives of monetary policy can be no different from the overall objectives of economic policy. The broad objectives have been: one, to maintain a reasonable degree of price stability and to help accelerate the rate of economic growth. Nothing to do with fake currency. Fake currency will always be there. Even today it's there. Black money will always be there as long as people hide their incomes and don't pay tax. It will be black money. And as my Lord Justice Nazir said, terrorism can be financed by both by fake currency as well as genuine currency. These have never, demonetization has never been considered a part of monetary policy. Monetary policy is only concerned with price stability. Now some countries add the other objective. US employment is added. In India, right, price stability along with supporting growth. That is the objective. Therefore, Millard, please don't be intimidated, and I'm sure your lordships are not, by the words monetary policy and economic policy. This is a simple act of declaring currency as no longer legal tender. There is a decision-making process. Your lordships can examine the decision-making process, and your lordships can even examine the decision if it is manifestly arbitrary and absurd. I'm not saying it's manifestly arbitrary. I'm only saying please examine the decision-making process. If that decision-making process is flawed, then the decision must go. Now, the next submission is kindly see two judgments. How this matter relating to economic policy have been observed, that have been approached by the courts. First, take, my Lord, the internet judgment itself. There also, it was said it's economic policy. RBI was involved. But kindly see.
T20.
Did you say it? No.
Yes.
274. Kindly come to, I'll quickly run through the paragraph. Kindly come to
Yes,
49,
yes.
last sentence. Keeping this birth chart of virtual currencies in mind, let us now see how the petitioners are aggrieved by the impugned decisions, the grounds on which they challenge the same, and the justification sought to be provided by RBI. Over the page, 50.2. This is the submission, item 1. Application of mind, satisfaction, relevant and irrelevant consideration. This is the submission. Now kindly come to paragraph 73. Page 323. Though the expression monetary policy is not defined in the Act, an entire chapter under the title Monetary Policy containing sections 45Z to 45ZO was inserted as chapter 3F. The provisions of this chapter are given overriding effect upon other provisions of the Act under section 45Z. Under section 45ZA1, the central government is empowered to determine the inflation target in terms of consumer price index once in 5 years in consultation with RBI. The policy rate required to achieve the inflation target is to be determined by a monetary policy committee constituted under section 45ZE. Now look at the RBI Act, madam. Chapter 3F, if there is the same book, Miller, it will be around page 64 or so.
Yes.
Chapter 3F, monetary policy. The important sections are 45ZA. Central government shall determine the inflation target. They have determined it as 4 plus or minus 2. Then there's the Monetary Policy Committee. 45ZM, Monetary Policy Report. And 45ZN is the important section. Where the bank fails to meet the inflation target, it shall set out in a report to the central government the reasons for failure to achieve the inflation target, remedial actions, estimate of the time period within which the inflation target. For the first time, this power has been invoked and RBI is in the process of submitting a report to the central government. Therefore, monetary policy is concerned with inflation. Then kindly see paragraph 163. Mode of exercise of power. That takes us to the next question, whether the power is exercised properly in a manner prescribed by law.
What, which paragraph?
163.
Just one second.
At
Yes,
page 366.
yes, we have.
That takes us to the next question, whether the power is exercised properly in a manner prescribed by law. Then kindly come down to placitum C. Satisfaction can be arrived at only by 1, gathering facts, 2, sifting relevant material from those which are irrelevant, and 3, forming an opinion about the cause and connection between relevant material and the decision proposed to be taken. In respect of each of these requirements, the learned counsel relied upon certain judicial precedents. Now, kindly come to paragraph 168. In fact, RBI cannot even be accused of not taking note of relevant considerations or taking into account irrelevant considerations. RBI has taken into account only those considerations which multinational bodies and regulators of various countries have taken into account. This can be seen even from the earliest press release dated 24/12 and is more elaborate than the impugned circular dated 6/4. The press release dated 24/12 states as follows. Then kindly come to 169. When a series of steps taken by a statutory authority over a period of 5 years disclose in detail what triggered their action, it is not possible to see the last of the orders in the series in isolation and conclude that the satisfaction arrived at by the authority is not reflected appropriately. In any case, pursuant on order passed by this court, RBI has given a detailed point-wise reply to the representations of the petitioners. In these representations, petitioners have highlighted all considerations that they thought was relevant. RBI has given its detailed responses. Therefore, the contention that there was no application of mind and relevant considerations were omitted loses its vigor in view of subsequent developments. Then, my lord, they say you must defer to the RBI. Now, kindly come to paragraph 191. I'm not disputing that your lordship will defer after looking into whether they have taken into account relevant considerations. 191. On the primary question. Now skip all that, my lord. Kindly come to the last 5 lines. In fact, even the learned counsel for the petitioners has added item with counsel for RBI that economic regulations require due judicial deference. The actual argument of the learned counsel for the petitioners is that such deference may differ in degree from being very weak in respect of a decision of a statutory authority to being very strong in respect of a legislative enactment. Then kindly come to 193. The next ground of attack is on the basis of Article 19(1)(g), proportionality. Kindly come to 194. The parameters laid down in Mohammed Farooq are unimpeachable. While testing the validity of a law imposing a restriction on the carrying on of a business or profession, the court must, as formulated in Mohammed Farooq, attempt an evaluation, direct and immediate impact upon the fundamental rights. The larger public interest ought to be ensured in the light of objects ought to be achieved, the necessity to restrict citizens' freedom, the inherent pernicious nature of the act prohibited, the possibility of achieving the same by imposing a less drastic restraint. 195 is important. There can also be no quarrel with a proposition. Banking channels provide the lifeline of any business. This is especially so in the light of restrictions on cash transactions, etc., when currency itself has undergone a metamorphosis over the centuries from stone to metal to paperless, and we've ushered into the digital age. Cashless transactions require banking channels. Therefore, the moment a person is deprived of the facility of operating a bank account, the lifeline of his trade or business is severed, resulting in the trade or business getting automatically shut down. Hence, the burden of showing that larger public interest warranted such a serious restriction bordering on prohibition is heavily on RBI. Now kindly come to paragraph 207. But nevertheless, the measure taken by the RBI should pass the test of proportionality, since the impugned circular has almost wiped out the VC exchanges. On a question of proportionality, learned counsel for the petitioner relies upon the 4-pronged test summed up in the opinion of the majority in Modern Dental. The 4 tests are: measure is designed for a proper purpose, measures are rationally connected, there are no alternative less invasive measures, and there is a proper relation between the importance of achieving the aim and the importance of limiting the right. Then kindly come to 211. The quotation from Lord Reed, next page, subpara 70. As I have mentioned, proportionality is also a concept applied by the European Court of Human Rights. I'm not reading the rest. Then 71. An assessment of proportionality inevitably involves a value judgment at a stage at which a balance has to be struck between the importance of the objective pursuit and the value of the right intruded upon. The principle does not, however, entitle the court simply to substitute their own assessment for that of the decision maker. I'm not even arguing that one. Then 212.4. In this case, the court concluded at page 387, singling out Bank Mellat, according to the court, was arbitrary and irrational and disproportionate to any contribution which it could rationally be expected to make to the directions objective. So the decision itself was questioned as irrational. Now kindly come to 213. We cannot and need not go as far as the majority had gone on Bank Mellat. UK has a statute where standards of procedure for judicial review are set out and majority decisions in the application of those standards. But even by our own standards, we are obliged to see if there were less intrusive measures available and whether RBI has at least considered these alternatives. On the question of availability of alternatives, the July 2018 report is relied upon by Shri Sood. The relevant portion reads as follows. Kindly come to paragraph 224. It is no doubt true, page 397, that RBI has very wide powers, not only in view of the statutory scheme or the three enactments indicated earlier, but also in view of the special place and role it has in the economy of the country. Those powers can be exercised both in the form of preventive as well as curative measures. But the availability of power is different from the manner and extent in which can be exercised. Kindly note that sentence. Different from the manner in which it can be exercised and the extent to which it can be exercised. While we have recognized elsewhere in this order the power of RBI to take a preemptive action, we are testing in this part the order, the proportionality of such measure, for the determination of which RBI needs to show at least some semblance of any damage suffered by its regulated entities, but there is none. When the consistent stand of RBI is that they have not banned the VCs, and when the government of India is unable to take a call, despite several committees coming up with several proposals, both of which advocated exactly opposite positions, it is not possible for us to hold the impugned measure is proportional. And 225 minutes, they, on the ground of proportionality, they set it aside. Now apply the same test. Please look at the material. Please satisfy yourself that it was material relevant to demonetization at 86.4% of the crimes. I'm not even asking your lordships to look at the outcome of their action. More or less, Milord, I've heard the learned Attorney General say it twice, and the learned counsel for the RBI said at least thrice. We may have failed in the objectives. But that is candor, and I appreciate that. But I'm not asking your lordship to judge by the outcome. I'm asking your lordships to judge at the time the decision was taken. If the decision was taken in good faith after taking into relevant consideration and eschewing irrelevant consideration and keeping the enormity of the action, that 86.4% of the currency will be withdrawn, then your lordships will uphold it. But if your lordships come to the conclusion, I don't find any material, and certainly the material does not seem to be relevant, and certainly the material does not have taken into account the enormity of the action, then your lordship will strike it down. Now, my lord, finally, in this compilation which I gave, completely a bogey is put forward saying it has been validated by Parliament. I was surprised. Where is the validation? There's no validation at all. Your lordship remembers, under the RBI Act, there are two sections. One, 26(1), by which the government guarantees the legal tenure. And then there is a liability on the bank, RBI, under section 34. This is shown as a liability of the issue department in the balance sheet. Please see those two sections, Milord. All that the Parliament did was recognizing the fait accompli of demonetization, and it says so. In fact, the section says so. We have to now discharge the guarantee and extinguish the liability. That does not mean that demonetization was validated. What does validating mean? Validating acts are where the court has struck down something or there's a flaw in the earlier decision. The subsequent law retrospectively validates the action or tries to overcome this judgment of the court. So validation means there is an error, there is a flaw, there is an illegality, which we overcome by validating. There are cases there is no flaw in our decision to demonetize. So what is the validation? Please see 26(1). Without reading 26(1) or 34, Your Lordship won't understand the 2017 Act, meaning of 2017 Act. And the minister's speech, which I've enclosed, I'll read it, says this is the only purpose, not to validate. Please see 26(1). Subject to the provisions of subsection 2, every banknote shall be legal tender and shall be guaranteed by the central government. So there's a guarantee. Now kindly come to 34. The liabilities of the issue department shall be an amount equal to the total amount of the currency notes of the government for the time being in circulation. So currency in circulation is always shown as a liability. When the currency comes back, it is shown as an asset and the liability gets extinguished. That is how, my lord, 15 lakh crore was the liability. When 99% of the notes came back, no, the liability, but then there's still some liability on the balance sheet because there's issue new notes. There is a liability for the old note replaced by the new notes. Now, what does this Act of 2017 say? Please see the 2017 Act. It is there, my lord, in the compilation which I gave. This item 4, page 20. Item 4, the compilation which I gave to your lordship now. What does the Minister of Finance say? Honorable Chairperson, on 8th November, government had announced that the high denominational currency ceased to be legal tender for various rationales and reasons. Then I skipped the paragraph because that all talks about the objectives. Then, the period under which it ceased to be a legal tender was from 8th November to 30th November. The Prime Minister had also announced that on such terms and conditions, this period would be extended to facilitate certain category of cases which the RBI had independently announced in the case of either the NRI who were living abroad or even Indian residents who were traveling abroad. Now, this having taken place, the next logical consequence of this was the RBI's commitment under section 34(1) of the RBI Act in order to pay the holder that currency shall cease to exist once the period is over. Additionally, under section 26(1), the guarantee given by the Government of India with regard to the payment of that amount also gets extinguished and it ceases to exist. It is therefore necessary that a parliamentary legislation to this effect be brought. I may mention that on 2 earlier occasions in 1946 and 1978, where similar steps had been taken, in the very first instance itself, a parliamentary legislation had been brought either through an ordinance and subsequent ratification by Parliament. Therefore, my lord, this was the only purpose of this Act, to extinguish the liability under 34 and to discharge the guarantee under 26(1). not to validate demonetization. But that is a,
Chidambaram, you can read it further also.
yes, I'll read. So this time has been done, this time it has been done in two stages. Under section 26(2) of the RBI.
Before that, the question, why was it not done this time?
No, it could have been done. It could have been done simultaneously. But they didn't do it.
So the answer is not from the first line, it is because.
It is because that this power under 26(2) also, that is also a legal. No, why was it not done this time? No, it's a non-answer. Mr. Premachandran is asking, why did you not do it simultaneously along with 8th November? Answer is because there is power under 26(2). What I understand is last time demonetization was done by legislation and therefore they did it simultaneously. This time it was done under 26(2). There was no legislation and we are doing it now. That is the meaning I attribute to Mr. Jaitley's answer. Demonetization done by legislation, the legislature extinguished the liability and discharged the guarantee. Here, it was done by an executive order of the RBI. There was no legislation at that time. Therefore, it could not have been done by could have been done by an ordinance on the next day, but they didn't do it. Apparently, they were advised that this has to be done, and they did it. All that they did was extinguish the liability under 34 and discharge the guarantee under 26(1). Nothing more. Certainly a far cry. Nowhere does the minister use the word validate. Nowhere does the act say it's a validating law. And kindly see the statement of objects also. I've attached the statement of objects. Kindly see paragraph 2. Subsequent to the issuance of the aforesaid notification, it was felt necessary to provide clarity and finality. SOR is also very clear, Mala. Minister's speech and SOR are clear. Subsection 1 of 34, liability shall be equal, discharge its liabilities. Paragraph A, last line, discharge its liabilities. And then B, last line, 26(1), withdraw the guarantee. These are the two objectives. Certainly not to validate the act they did. Well, it's completely wrong to say that anything was validated. It is not a validating act at all. The act was only to discharge the liability and to extinguish the guarantee. Finally, my lord, the argument is it's futile. So effectively what they are saying is you're all wasting your time. You can't issue an order. The answer is, in my original note, I have given two judgments where this court has categorically said, even if we can't grant any relief, we can prospectively overrule and we can lay down the law for the future. S.R. Bommai is absolutely clear. Justice Pandian, who I agreed with Justice Jeevan Reddy's judgment for himself and Justice Agarwal, and the other judgment of Justice Sawant, 5 judges have categorically held we are not able to grant any relief because elections have taken place. Those 2 paragraphs alone I'll give at page in the report 1994, 3 SEC page 1 at page 149 and 299. 1994, 3 SEC page 1 at page 149. They have got it. One 149, last paragraph. Roman 9. The proclamations dated so and so. The action taken by the president in Karnataka and Meghalaya are unconstitutional. Proclamation in respect of Nagaland is also held unconstitutional. However, in view of the fact that fresh elections have taken place and the new legislative assemblies and ministries have been constituted, no relief is granted consequent upon the declaration. Then the other judgment which constitutes the majority, it's at page 299. Justice Jeevan Reddy. Kindly see Milad, 298. Paragraph 11. The proclamation dated so and so in respect to Meghalaya are unconstitutional, but for the fact that fresh elections have since taken place in both the states and new legislative assemblies and governments have come into existence, we would have formally struck down the proclamation, etc. Therefore, my lord, even if your lordships are unable to grant relief of striking down the demonetization, because it's done and dusted, it's a fait accompli, because your lordships are hearing the case 6 years later, your lordships can certainly pronounce on the decision-making process and on the decision, and then say what is the true meaning of 26(1) and 26(2). What is the difference between demonetization through plenary legislation and demonetization through 26(1), and explain what the decision-making process ought to be, and pronounce on whether the decision-making process in this case has been fair, and finally comment upon the proportionality of the action. Your lordship should do that in future. Who knows, my lord? We may not, I hope, have a government like Zimbabwe or Argentina, and which will come and one day say, we demonetize 100% of the currency in circulation. Therefore, my lord, my learned friends have almost mocked me for saying 86.4. But 86.4 is an enormous proportion. And if you allow them this leeway of without a transparent decision-making process and a proportional decision, a government tomorrow can say, if I can do 86.4, I can do 95.4 also. Then another government can say, I can do 99.4. Another government can say, I can do 99.9. That is not the power. That is never the power of RBI or the government. Government may have done it in parliament. We would have stopped it in parliament. Who are parliamentarians who would have stopped it. But they didn't bring it in parliament this time. Even the budget discussion which took place subsequently, the entire budget discussion was castigating the government for demonetization, be that as it may. But it's done deed. Therefore, certainly, my lord, I would appeal to your lordships, show deference, but let them show deference to you by placing the papers. Your lordship is invited to show deference to them. They will not show deference to you. Let them show deference to you and place the papers, and please satisfy yourself whether the decision-making process has been fair and proportional. And declare the law, my lord, so that it may guide your future. I'm obliged. I'm deeply obliged.
Namdevan, how long will you take?
It was in my estimation about 40-45 minutes.
Internet has been cited in a subsequent judgment, which my lady Justice Nagaratna was a party, 2022, 3 SCC 694, paragraph 65 and 66. Only the paragraph numbers, paragraph 65 and 66. Would your lordships allow me to submit a 2-page
Yes, we will permit it. We will.
what I've said in the
We will
case law? It won't exceed 2, maybe 3 pages, no more than that. Okay? Obliged, my lord. Deeply obliged.
Yeah, the other case, you know, the other case, we may not take up tomorrow because this case will take some time. And we will adjourn it. Let us see how things take. Tomorrow it won't come.
Then day after.
Day after tomorrow is, one day it is not possible. Friday is a miscellaneous day.
Correct.
We will see, we will fix the date later. Tomorrow it won't come.
Inform the Solicitor General.
Huh?
I will inform the Solicitor General. He was appearing. for this.
Yes, yes, you please convey that. Other case, the other case. Will stop in 4 weeks.
Next week, not Monday, your lordship may not.
Monday is again a miscellaneous, whole week is miscellaneous week.
Okay. Okay.
Let us see how things take shape.
Otherwise, I would have taken only about an hour and a half of it.
No, all cases will begin like that only. And you have seen, initially we thought this is a dead case and how it has taken shape.
Then kindly list it on a date, my lord, because.
No, we will fix a date little later.
Mr. Gaurav and me have been putting our heads on it and
No.
now that we have done it, I'm eager to. Next week also for 2 days, if your lordship can spare. we
Next
can do.
week, because we have miscellaneous week.
Even if it's miscellaneous, doesn't matter.
No.
2 days.
All right, let us see.
All right.
Tomorrow, Mr. Shamdeep. What do you want to say? Huh? Not now, sir. Not now. We are really tired, sir. Huh? No, sir. Tomorrow it will be reserved. How is it possible? You should understand. Huh? Definitely. You can, definitely. I thought you were taking 2 weeks. And I thought it is a very weak submission. All right. What? No, sir. You have completed. No 5 minutes. You have already completed.
I have something to say.
This will come under what section? Main argument, then reply and rejoinder, and you have already done both, you know. No, sir.
Regarding the black money aspect.
No. Bus.
Even those.
Enough. Right.
Yes, it is on the agenda.